2022
Yes, it was.
at that hospital.
Yes.
Your Honor, at this time, the state would tender Dr. Drennan as an expert of neonatal medicine and pediatrics.
Any objection?
No, sir.
All right, Dr. Drennan is recognized as an expert in the field of neonatal medicine and as a pediatrician.
Thank you. Dr. Drennan, did you receive an infant into your care in January of 2022 from Hobbs, New Mexico?
Yes, I did.
Okay. Do you recall specifically what date you received that infant?
I received a phone call overnight. I was the physician on call the night of the January 7th going into the morning of the 8th. And we received the infant on the morning of the 8th. Our admission documentation says at approximately 02:30.
Okay. Did you have to agree to receive that infant into your care at Covenant? How does that process work?
Yes, so I received a phone call from one of my pediatric ER colleagues who asked me if this is a patient that I thought was appropriate for the neonatal ICU. She gave me some of the medical information of the patient and asked if this would be an appropriate admission that I'd be willing to accept to our unit.
And did you agree?
I did.
Why specifically would it be appropriate for this patient to come to your facility, Covenant Children's, versus being cared for in an ER unit in Hobbs?
So when a newborn baby is delivered, there's really two different options in the hospital setting for where they're going to be admitted. The first of which is the mother-baby unit. That's an area for healthy term or near-term babies. And those are babies who aren't needing ongoing medical care. They generally stay with their family for the majority of their time in the mom's room, and then they may briefly visit the newborn nursery with a nurse, but they're not infants who need ongoing medical support, things like oxygen, fluids, and so on. If the baby is needing those sorts of interventions, then the place that they would receive their care is in the neonatal ICU unit. So it seemed like this patient was needing ongoing support and would best be cared for in the NICU setting.
And tell me about the neonatal or NICU unit at Covenant Children's. Tell the jury about the specialties that Covenant Children's can offer in those units.
So our NICU is a level 4 NICU. That means it's designated by the state as being the highest level of NICU, which can take care of a variety of very ill patients and can receive a lot of different subspecialty services as needed.
And are those, would you say, more specialized than a general hospital?
Yes, they are.
All right. So you said you received this infant patient on the morning of the 8th. What was the first step you took in assessing this patient?
So first, I looked at the patient's vital signs and then did a physical examination.
And if you, well, let me start. Were the vital signs normal, or did you observe any cause for concern when assessing the vital signs?
With the baby on oxygen, the vital signs were normal.
Is it common for a newborn to be on oxygen at this stage?
There's a small percentage of term infants that may require oxygen after delivery.
And was this baby a term infant?
Yes.
Do you know why this term infant was required to have oxygen at the time you took him into your care?
There would be a differential diagnosis or a list of several different possibilities.
Did you have a list of those possibilities, or did you make a list of possibilities?
So in my mind, this could be transient tachypnea of the newborn. which is where about 1 to 2% of infants need some oxygen as they're making that transition from a fetal to a neonatal physiology state. This baby may also have needed oxygen because of the prior history that I received from the ER physician, which is that this baby was very cold, had a low heart rate, had a low blood pressure. All of those things together painted in my mind the picture of cold shock.
And what is cold shock?
So it's basically when the body temperature is extremely low and outside of the range of normal. The body is made to work under a very strict range of temperatures, and so when you start to deviate outside of that, the physiology of the body changes. Your heart rate and blood pressure can begin to go down. It becomes difficult to adequately get blood flow and oxygen to your tissues and your vital organs.
All right, so you mentioned the vital signs, and then you mentioned a physical assessment. What, if anything, did you note during your physical examination of this patient?
The remarkable things I noted were that the baby was very pale in color and had generalized hypotonia, which just means the baby was slightly more on the floppy side than what I would expect for a term infant to be at this age.
Is that the same thing, Dr. Drennan, as low tone?
Yes, ma'am.
Okay. Is that just another medical name for it?
Yes.
All right. Anything else of note during the physical assessment of this patient?
Just those two things, and then that the baby was on oxygen.
Did you order any additional tests for this infant?
I did. We ordered lab work and also ordered head ultrasound in addition to testing for kind of maternal serology sort of things. So that would be checking things like hepatitis B, HIV, syphilis, things like that, because we didn't have a maternal history. And then we ordered blood counts, blood chemistries, the blood gas.
Was the blood count part of the lab work that you just mentioned you ordered?
Yes, it was.
Okay, and did you receive that lab work back, or did that go to a different physician?
It came to me.
Okay, what do you recall about the blood count?
The patient's hematocrit was 26, which is extremely low. This means that the baby was profoundly anemic.
And what does that mean when you say profoundly anemic?
This means that the baby's blood counts were much lower than what we would anticipate for a normal newborn infant to be at the time of delivery.
Is there, you mentioned the blood count was at 26, if I heard you correctly. Is there a range of what you would expect a newborn to be within?
Most babies will fall between about 45 to 65.
All right, and then anything else of note that came back on the lab work besides the low blood count?
We did have a positive screen for opiates as well. And the creatinine was elevated, which is a marker of kidney function. And then one of the transaminases, which is a liver marker, was also elevated.
You said elevated creatinine. What does that mean in terms of kidney function?
So that means there's been some sort of acute kidney injury. That can happen for a variety of different reasons. But anything above 1.5 would be considered abnormal.
And what was the infant you were caring for at?
It was 1.6.
And then you also mentioned a head ultrasound. Okay. Did anything come back from the head ultrasound?
The head ultrasound was normal.
Did you know any physical injury to the infant patient?
I did not.
Given the tests that were received and based on your assessment, what were your recommendations for ongoing care for this patient?
Our recommendations at the time were to continue the oxygen. We actually did trial off briefly, and the baby's oxygen saturations went down at that time, so we replaced the nasal cannula into the nose and continued oxygen therapy. We continued with IV fluid administration and prophylactic antibiotics while waiting for the blood culture. That's how we rule out an infectious process. And I also recommended a blood transfusion.
Why did you recommend that?
The baby's blood counts were significantly low, which meet our unit protocol for a threshold at which we should transfuse a baby.
And are you aware if a transfusion actually occurred?
It did.
I have a moment, Your Honor.
You may.
My last question, Dr. Drennan, is did you care for this infant patient the entire time it was at Covenant Children's Hospital in Lubbock?
No, I was the overnight physician on the nights of the 7th, 8th, and 9th.
So are you aware of which doctor or physician took over following your care?
I passed off in the morning to the daytime physician, which was Dr. Bowman.
Thank you. No further questions, Your Honor. We'll pass the witness.
Cross-exam,
Yes, sir.
Mr. Conlon.
Good morning.
Good morning.
Dr. Brennan. Let's get situated here. Let's see here. So as stages to get going here, so stated on direct examination, you've been a doctor for 10 years. And were you a neonatologist all that time?
I've worked primarily in the NICU setting for the last 7 years.
Okay. So majority of your practice has been that.
Yes.
And you mentioned you mentioned NICU, and that's that. Can you tell us what that acronym is if you haven't already?
Neonatal intensive care unit.
Okay, so kind of similar to ICU.
Yes.
For babies. But like 28 days is the limit essentially for the age of infants you receive into that unit. Is that, am I understanding that correctly?
So neonate generally refers to the first 28 days of life. We take babies after they are born. And that can be if they're born in the hospital setting, home, midwife center, etc. We then keep them in the NICU as long as they need ongoing care until they're ready for discharge. That could be longer than 28 days if
Okay.
needed.
Okay, because my understanding was maybe at 28 days that somebody else, the infant, not this particular infant, but a particular infant might just go somewhere else. But I'm mistaken about that.
They'll continue to stay with us.
Right,
yes.
and so like what you said earlier is that there's two options, right? So typically, kids are gonna go to the mom unit, right? And then if they have issues, they go to NICU.
Yes.
But when there are no longer issues, you just release them, they're discharged. They don't go to like, back to mom unit, typically, right?
They rarely do if it's a very short stay. Moms typically are only in the hospital for 2 or 3 days following delivery. So if it's a very transient issue, then sometimes the babies do go back to the mother-baby unit.
Okay. But in this particular case, this child was discharged, do you know how long, from NICU? And when was the infant?
On the 13th.
On the 13th. So you received the infant the 8th, and then the 13th, the baby was literally discharged.
That's correct.
And so didn't go to some other unit in the hospital, literally was discharged to whomever took care of that child in the public.
Yes.
Okay. same thing, I don't think it'll be that long. So you talked about, and I know this is just something you've already said, but just to reiterate, when the infant was received by you, the 8th, and you said about 2:30 in the morning,
Correct.
vital signs were normal. Yes, there was oxygen being administered, but otherwise, vital signs were normal.
Yes, that's correct.
And now, critical care progress notes, are those something that you personally like type in on a laptop while you're on call and caring for a patient?
We're responsible for documentation if there's an admission, or the daytime physician is responsible for documentation of a progress note or discharge summary, whatever is appropriate for that day.
Just because I have critical care progress notes that have your name as the admin physician, is that right? It's ADM physician, administering physician, is that
Yes.
that? Okay, so, but I think there's dates in there, like after the 8th, like entries. I mean, unless I'm reading them
So I was the admitting physician on the 8th,
wrong.
and then following my care, the daytime physician would have been Dr. Bowman the subsequent morning.
Okay, and just before I forget, you mentioned the color that the infant was pale and there was a low tone, but it's true that by the 9th, that had reversed itself. There was no, tone was normal. This tone issue or floppy was normal for an infant at that age, or at, yeah, that, I think you guys use a more technical term. If you could help me with that.
It is documented as normalized.
Right, like on the 9th.
Correct.
Okay. So the low tone issue is resolved, at least from a physician standpoint, by the 9th.
Yes.
That's like the next day, right?
Correct.
In fact, the baby was noted as being like pink. And so no longer did the baby appear as it appeared when you received the 2:30 in the morning on the 8th, right?
Correct.
Just make sure I'm not missing anything. In fact, wouldn't you agree with me, I mean, that like, in essence, by the 9th, the notes are indicate that outside of what we all might know, this infant appeared to be a normal, healthy baby.
This baby was improving because of medical treatment.
Sure, yeah.
Yes.
So no doubt you guys administered medical treatment, that's to be commended. But nevertheless, on the 9th, all things being equal, you look at this child, and for all intents and purposes, it's a normal, healthy infant, by all appearances.
By
Correct?
physical appearances, yes.
Okay. Now, I noticed that you classified the infant as having been abandoned at birth. Is that right? Is that the way you classified
I
it?
don't know that I use that terminology.
Would it help refresh your memory if I showed you the critical care progress notes?
Sure.
May I approach it?
You may.
Just, oh, sorry. It's, if it's not very it's not very Right. So I just, when I made the mistake, I'm just looking at this.
Okay.
If you want.
Just as a critical care progress note, I was the admitting physician, so mine would be just the admission, history, and physical.
But I'm not mistaken in that somebody in the process of receiving this infant identified it as having been abandoned at birth.
Objection. Objection, hearsay.
Overruled.
Is that right?
Yes, somebody did classify it as such.
Just bear with me, ma'am. I just don't want this.
You may.
That's all I have. Thank you, ma'am, for
Thank you.
your time.
Read your right.
Wait for murder.
Sorry, counsel, just.
Dr. Drennan, you were asked by defense counsel on cross that by the morning of the night low tone had improved. I believe you said to normal. Is that correct?
Yes.
Or it had improved at least. Had you administered care you were hoping would cause improvement in this infant patient?
Yes, I think that the blood transfusion, the fluids, and the baby being at a normal body temperature definitely made it possible where the baby's tone was beginning to improve by that point.
And then you were also asked on cross-examination regarding the physical appearance, which you said was normal, but how about internally was the patient?
I'm going to object to lack of foundation, Judge.
Sustained.
Okay. You classified the physical appearance as normal. Was there anything going on with this patient that wasn't classified as normal?
The physical exam portion was normal. Anytime we see markers of elevated creatinine and liver enzymes, we know that there was some degree of damage that happened to those vital organs, and so that is an infant who was at risk for having injury to the kidneys, the liver, the heart, the brain. all
I'm
of
going to
these.
object again, Judge. It's, I believe this is lacks foundation.
I'll sustain it, but you can go ahead and develop a little bit of foundation.
Okay. And I know you covered it, so to be clear, you were addressing high creatine levels in your care,
Yes,
and you were addressing continued oxygen therapy,
yes,
and you were addressing low blood count through the transfusion.
yes.
And then you, lastly, Dr. Drennan, were asked about discharge once a patient leaves your unit. Do you recall that line of questioning or cross-examination? Is it common for doctors upon release from your unit to make recommendations for the discharge of a patient?
Yes, it is.
And is that something that's required, or is that just something that's within your purview as a treating physician if ongoing care is recommended?
There's always the recommendation to continue care with a pediatrician.
May I have a moment, Your Honor?
You may.
Great, nothing further from the state.
Any follow-up from the defendant?
No, sir, thank you.
Any questions from the jury of Dr. Drennan? Any objection to excusing Dr. Drennan?
Not for a statement.
No, sir, that's fine.
You're excused, thank you. Call your next witness.
State calls Dr. Bowman.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of law? You may be seated, sir. Thank you.
Good morning, Dr. Bowman, if you will give your full name for the record.
Yes, I'm Dr. Thomas Andrew Bowman.
And what is your current position?
I'm an attending neonatologist at Covenant Women's and Children's Hospital.
And what city and state is that located?
It's in Lubbock, Texas.
Tell the jury a little bit about your educational background.
I went to college at Abilene Christian University and then medical school at Texas Tech University, residency also at Texas Tech and University Medical Center, and then fellowship training at the University of Virginia.
Now, do you have a specialty in medicine?
Yes, so I'm board certified in neonatal perinatal medicine since 2012 and board certified general pediatrician since 2008.
And how long have you been with Covenant?
I've been at Covenant since late 2013 and for a couple of years worked in Midland and then have been back at Covenant now for 4 or 5 years.
And in your field, are you required to keep current with research and education, not only for your, just your regular pediatric license, but your specialty as well?
Yes, so for both the medical licensure and for board certification, there is a requirement for continuing medical education in the field of neonatology, which I keep up to date.
Your Honor, I would offer Dr. Bowman as an expert in neonatal medicine and pediatrics.
Your Honor, may we approach?
You may approach. The court recognizes Dr. Bowman as an expert in the field of neonatal medicine and as a pediatrician and may give an expert opinion in those areas.
Thank you. Dr. Bowman, tell the jury, specifically at Covenant Women and Children's Hospital, is there a unit within that hospital that is specific to your specialty?
Yes, the neonatal ICU.
And tell us a little bit about that unit. Like, how does it operate? Just a little bit of its general information.
Yeah, so the neonatal ICU is specifically designed to care for sick and premature newborns. It's staffed by a number of specially trained nurses, respiratory therapists, additional therapy staff, and then there's 4 neonatologists that are in the building. We split time 24/7 in the building, ready to respond to any needs that the patients in that unit may have.
Would one of those neonatologists be Dr. Drennan?
Yes, Dr. Drennan is one of my colleagues.
Would one of those be Dr. Kumar?
Yes, Dr. Kumar is one of my colleagues as well.
And then who's the fourth?
Dr. Sparks.
Thank you. Now, are you assigned, I don't know if it's shifts or rotations that you as the physician work caring for these patients since they're the 4 specialists?
Yes, so we take shifts being in the building, in the hospital.
And is there a team, so to speak, that cares for these newborn infants that include yourself as a specialist, as well as a number of other staff and members of the medical team?
Yes.
And can you just kind of briefly explain that for the jury, how that works?
Yeah, so the neonatologist is the physician responsible for the babies in the NICU. But like I said, there's nurses, respiratory therapists, speech therapists, occupational therapy, physical therapy, social workers, there's all the management folks that are all focused on working as a team to help take care of the babies.
Now, did you become involved with the care of a male baby on date of birth 1/7/22? Did you become involved in the care of that child?
Yes.
When did you become involved?
So I came on shift the morning of the 8th. So the baby was admitted in the early morning hours, roughly 0300, to our unit, and Dr. Drennan was on service at that time. So she admitted the patient and did the initial care, and she was the overnight person, and so I was the daytime person who came in at 8 o'clock on the morning of the 8th and assumed care then.
And before I ask kind of how that went, let's kind of talk about how long were you the physician that cared for this baby boy?
I had the daytime shift on the 8th, so that's from 8 a.m. to 5 p.m. on the 8th. And then again, I was continuing my run of days on the 9th, so the 9th from 8 a.m. to 5 p.m.
Now, when you came on shift, this may not have been obviously your only patient that you had, but let's talk specifically, how was this baby boy doing?
At the time I came on shift, he had been stabilized nicely. His vital signs were within normal limits, and he was alert and active.
And did you review what care he'd been given to see why he was now doing well?
Yes.
And what was that?
So I got a sign out from Dr. Drennan, so she told me what she had received from the referring physician, and I looked at what all had been done by the ER as well as the Dr. Drennan the night overnight. So specifically the things that helped stabilize the child, one was warming him up. He was very, very cold. If I recall correctly, it was in the 27 or 28 degrees Celsius, which is almost 18 or so degrees Fahrenheit less than normal. So he was warned. He had signs of dehydration, so he was given a fluid, IV fluid, resuscitation fluid bolus to resolve his dehydration. And then also specifically, it was very anemic. He had very low blood counts, and so he received a blood transfusion that Dr. Drennan ordered overnight. And those things, I think, are all things that led to improving his clinical status.
Now, during the time that he was under your daytime care, what sort of things were you looking for to see if the progress was continuing, or maybe it was not, it was just kind of stagnant, or what was happening?
So we were following vital signs regularly, so monitoring heart rate and respiratory rate. During the daytime when I was on service, he was still requiring some respiratory support, so he had a nasal cannula delivering supplemental oxygen. And so he was, he needed that help, so we were monitoring that. And then also laboratory evaluations. So lab tests both on admission and then the following days to confirm that his anemia was stabilized, to confirm that his kidney function was improving, and to confirm that any evidence of injury to the liver was also improving.
Now, with infants, obviously newborns need some type of food or nourishment soon after they're born.
Yes.
And so this child obviously was presenting with some issues when he gets brought to the NICU. So how was he receiving what I'm just going to refer to as fluid? Did you correct me?
So they started, they gave him IV fluid. I believe I started at the outside hospital, and then we continued that on admission to the NICU.
Now, was he transitioning to where a normal infant would have been learning to either breastfeed or bottle feed upon birth?
Yes, and I don't recall specifically, but typically we would start with IV fluid and then slowly decrease the amount of IV fluid we give and increase the amount the baby would eat by mouth. I believe he was still on IV fluid through the day on the 8th. I can't recall exactly when we were able to come off IV fluid and he was able to support everything feeding by mouth.
Now, when infants intake fluid, fluid needs to come out to show that
Yeah.
things are functioning in a normal range. So was that something that you were monitoring as well?
Yeah, so following closely his urine output, which was, by the time I took over, his urine output had started to pick up, but I believe previously he had low urine output.
Now, since you came in, kind of, you had Dr. Drennan intaking, she had ordered a lot of things,
Mhm.
some testing, blood transfusion. You take over. Did you order anything additional, or were you reviewing maybe labs or testing results that came back?
Reviewing, mostly it was continuing care, so reviewing the stuff that had already been ordered and resulted. We sent serial laboratory testing the following day. I can't remember if I ordered it or if it was initiated previously, but we did some imaging studies too, x-rays, to confirm that there were no broken bones or anything like that.
Now, did you get results from the imaging, or is that a following care doctor?
No, we had that imaging, and fortunately there was no evidence of fractures.
Now, as you transitioned over to your second day with this baby boy, how was he progressing then on and on?
Overall, he progressed well. He moved in the right direction. So by the second day, on the 9th, the day I was on, he had been able to wean off of his respiratory support, so he no longer required supplemental oxygen, so his breathing was doing better. It was in the right direction. Again, I don't remember the exact pace at which, but he was able to wean off of IV fluid and start eating by mouth. So that's a movement in a positive direction. And then on laboratory testing, one of the name of the lab test that we do to look for how well the kidneys are functioning is the creatinine level. So creatinine is kind of like the trash the kidney takes out, and so if the kidneys are working well, then the creatinine is low. And so originally, sorry to speak, but the kidneys weren't taking out the trash very well. They started functioning better, taking out the trash better, so the creatinine level was lower on the following days.
Now, at the time that you were ending the night, your around 5 o'clock daytime shift with this baby boy, was there anything specific that you were noting in your progress notes for the next physician who would be taking over care of this baby?
It would be continuing to monitor the things that we've discussed, the physiologic stability, blood pressure, heart rate, respiratory, like that thing, and then continuing to monitor improvement in urine output and any evidence of long-term sequelae.
And we know that initially from the records that this baby had what some have called low tone or kind of a floppiness. By the end of your shift on the night, had that continued to progress and improve based on medical treatment?
Yes, it had improved.
Did you have any concerns at that point, or if everyone who was caring for this child continued, he should continue to progress well?
You always have concern, but my expectation, based on what I had seen and the progress that he had made, the expectation is that he would continue to improve.
Now, when you're ending your second day, you're going to change shifts, or
Yeah, that's the right word, hand off.
do you know who the next doctor is that's going to take over, or is that just like that's already like established? You put your notes in, and the next shift is coming in.
We hand off from one team to the next each day. So, like I said, I was the day guy. So Dr. Drennan was on at night, and so we would have a discussion in the morning at 8 and hand off all the patients. She would update me on what's been going on in the unit and what issues each baby is having. And then I would work all through the day, and then at 5 p.m., I believe both the 8th and the 9th were back handed off to Dr. Drennan. I don't recall the exact call schedule for the other folks, but at each handoff, we run the list and discuss the patients with the oncoming physician.
If I could have just a moment, Aaron.
You may.
I'll pass the witness.
Cross-exam.
Yes, sir.
Ms. Curley.
Your Honor, may I retrieve defense exhibits A through D?
You may.
Good morning, sir.
Hello.
Okay, so I just have a few questions for you. So one of the things that you noted and you testified to was that when you saw the baby, the first day you saw the baby that morning, you arrived on day shift, correct?
Yes, ma'am.
Okay, and you testified that the child had good vital signs.
To the best of my recollection, yeah.
Okay, and you also testified that there were 3 other could you pronounce that for me?
Neonatologists.
Neonatologists. There were 3 other neonatologists who were also caring for the child, correct?
There's 3 other neonatologists that are part of our group. There were only 2 other neonatologists that were participated in this patient's care.
Okay, perfect. So there were 2 others other than yourself that were helping care for the child?
Yes, Dr. Drennan and Dr. Kumar.
Okay. You testified that there were some labs that you ran on the child. I want to talk about those labs.
Sure.
Okay. What labs did you run?
So a complete blood count, which measures the different types of blood cells and the amounts, and electrolyte studies that measured the electrolytes in the blood, as well as some liver function testing. We did do some drug screening tests to see if the baby had any drugs in the system.
Okay, could you tell me about those screening tests?
Sure. There's 2 ways that we check for the presence of illicit drugs in a baby's system. One is a urine drug test, and that's relatively quick, and the results of that are available soon after we order the test. And then another way to test for drugs in the system of a baby is what's called meconium drug screening. So meconium is the poop that is in a fetus. It's the first, so that it actually collects and it's the stool that's in the baby's intestines during development. And so the first couple of stools that the baby passes, are that if y'all have babies, it's the black tarry stool that babies have the first couple of days. So you can send a sample of that and evaluate whether there's drugs in that.
Okay. And so you also ran a number of other tests, correct?
I'm confident we did. I don't recall precisely each lab test we did.
Okay. Are there certain tests you tend to run whenever you're caring for a child in your specific unit?
Yeah, what I've outlined, so often a CBC, the complete blood count, the electrolyte panels, and then on a case-by-case basis, drug screening would be indicated. Often we do labs that would evaluate for the possibility of infection.
Okay. And so are you screening for things such as HIV?
So thank you for jogging my memory. Yes, we did check for that in this particular baby. It is not part of the routine baby lab tests. There is a number of tests that are run on moms while they're pregnant, including HIV, hepatitis testing, syphilis testing. And if you know the mom's results of that, then you don't have to do testing on baby. In this case, we didn't know any of mom's results on any of that type of testing, and so we did need to test this baby.
Okay, so you, would it be correct to say that you did more testing on this child than any other because you didn't have the history of the mother?
Correct.
Okay. Do you recall any of the other tests you performed on the child?
Not off the top of my head. There may be others, but I don't recall the entire laboratory testing.
Do you recall giving a pretrial interview related to this case?
I do. I'm welcome to having my memory jogged.
Okay. Your Honor, may I refresh the witness's recollection with a transcript?
You may. But you need to first ask a question that he doesn't remember.
And just to be clear, you do not remember the other tests you ran, correct?
Not vaguely like that, no.
You may approach with the
Thank you.
Sure.
Okay. I'm going to specifically refer you to pages 10 and 11.
Sure.
Okay, and once you've had a chance to look over it, I'm going to ask to approach and get that copy.
So, are you
And one moment. So before I continue, I have to make sure your memory is refreshed. Do you believe your memory has been refreshed?
Yes.
Okay, Your Honor, may I approach you?
May.
Thank you.
Hang on, let me read 11. Okay.
Okay. Dr. Bowman, since your memory has been refreshed, could you tell us what other tests you ran?
So I think we're having a miscommunication. You're asking about testing, and I was thinking about laboratory testing. The portion of that interview that you reminded me of referred to a physical exam, the structured SARNOT scale. Is that what you're trying to ask about?
Yes, and so
Okay.
those tests.
Yes. So it's not specifically a test. It's a physical exam that is a way to score the neurologic effects that may result from hypoxia and ischemia.
Okay, and so I'm specifically referring to your testing of hepatitis B.
Oh, yeah, we also, yes, like I said, we tested hepatitis B, HIV, and syphilis
Okay.
because it wasn't available online.
Okay, you also indicated that you also tested for drugs.
Yes, we
Okay.
said that, yes.
And what were your results when you tested for drugs? Did you find any?
The urine drug screen was positive for opiates.
Dr. Bowman, have you had a chance to review the Lee Regional Medical Center report and discharge for Alexis Avila?
I have not.
Okay. Your Honor, at this time, defense would like to publish for the jury again the defendant's Exhibit A.
You may.
Thank you. Okay. That is a little upside down. I'm going to change it. Sir, are you able to see that?
Yes.
Okay, are you able to see what's under prescriptions?
Yes.
Okay, what is listed under prescriptions?
I think they were trying to say naproxen and Tylenol, with Tylenol 3 with codeine.
Okay, are either of those an opiate?
Codeine is.
Okay, so you saw the child on the 8th. Is it possible for codeine to remain in the system for that time period?
I believe so, yes.
Okay. Okay. And Dr. Bowman, you also indicated that at some point you and your team discharged the child. Is that correct?
Correct.
And you did not discharge him to another specialist. Is that correct?
I don't recall specifically. I believe it was to CPS, is who had custody at the time of discharge. Discharged to a home
Okay.
or to a non-healthcare facility.
Okay, perfect. And just to be clear, the child was stable when he was discharged?
Yes, ma'am.
Okay, and he had good vital signs?
Yes, ma'am.
Okay, and he had been in your facility for how long?
I believe it was the 13th of January, so it had been from the early morning of the 8th until sometime during the day on the 13th.
Your Honor, defense will pass this witness. Thank you.
Any redirect?
Yes, sir. Dr. Roman, tell the jury about opiates and what effects they have on a newborn.
There's variable effects, but it's negative. It is always better to not have opiate exposure to a fetus when you can avoid it.
I would concur with that.
Any follow-up?
No, Your Honor.
Any questions from the jury? Yes, if you'll write it, no, you need to write it down and give it to the bailiff. Thank you, sir.
So, put your name on it.
Thank you. There's a question from a juror that would like to know how long it would take with a baby in this condition, and I'm assuming they're meaning from the time of admission to get to stabilization.
Babies are resilient. I think this kid is a perfect case of demonstrating that. From the initial discovery of the child to the time of stabilization, I think was relatively quick. That's within less than 24 hours. And then I think this kid's course was probably, as far as the NICU recovery, is a reasonable amount of time. So with the 8th through the 13th was about 5 days. I think initial stabilization less than 24 hours, and then resolution of symptoms to the point of being safe for discharge on the order of 5 days is a reasonable time frame for each of those steps of recovery.
Thank you. Any other questions from the jury? Any follow-up from the state?
No, Your Honor.
Any follow-up from the defendant?
No, Your Honor.
Any objection to excusing Dr. Bowman?
No objection.
No objection.
You're excused, sir. Thank you. Call your next witness.
Yes, Your Honor. City Calls Detective Daniel Perez.
Is the jury doing okay? Anybody need a break? Break? Okay. All right, let's go ahead and take our morning break at this time. During the break, don't discuss the case. Don't allow anyone to discuss the case in your presence. Don't do any independent research about the case. Don't form any fixed opinions about the case until the case is finally submitted to you. Please stand for the jury. You may be seated. Anything we need to talk about before we go off record out of the presence of the jury?
Not from the city, Your Honor.
Not from the finance.
Okay, it's usually about 15 minutes. It's 9:22 now, so about 25. seated, thank you. Mr. Probasco, call your next witness.
Yes, Your Honor. The state calls Detective Daniel Perez.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of law?
Yes, sir.
You may be seated. Thank you, sir.
May I proceed, Your Honor?
You may.
Thank you. Sir, could you please introduce yourself to members of the jury by your first and last name?
Oh, yes, my name is Daniel Perez.
And where do you work?
I'm currently employed with the Hobbs Police Department.
How long have you been employed with the Hobbs Police Department?
Just a little over 3 years, but overall 8 years of law enforcement experience.
What other agencies have you worked for?
I've worked for the Sunland Park Police Department and the Allen Border Police Department.
In what capacity do you work for the Hobbs Police Department today?
That of a full-time salaried and commissioned detective assigned to the Criminal Investigations Division.
What other assignments have you had through the course of your law enforcement career?
I became a field training officer. I have maybe 400 to 500 hours of additional training to include homicide investigations, shooting reconstruction, even interview and interrogation techniques, background investigations, shooting reconstruction, violent crime apprehension type of additional training that I've had throughout the years.
And what drew you to a career in law enforcement?
I knew that serving my country was something that I wanted to do. As time went by, I knew I got a little older to join the military, so therefore becoming a first responder was also another way of serving my country, and I did.
All right, let's focus your attention to January of 2022, in particular January 7th of 2022.
Yes, sir.
What assignment did you have at that point in time in the Hobbs Police Department?
I was working as a full-time detective.
Were you involved in any investigations on January 7th of 2022?
I was the case agent involved in this matter.
And you've been present in the courtroom as case agent for the first couple days of testimony, is that right?
I have, yes.
So you've been able to hear witness testimony of your investigation, that included components of your investigation.
That's correct.
With regards to how you were first assigned to this case, how did that happen?
My work week that week was from Wednesday through Saturday, and as detectives, we are on call. We're subject to call at least one day for our work week, and my assigned day was that Friday, January 7th, 2022. I'm sorry.
And what was this investigation in relation to?
Involving a baby that was found inside a dumpster.
At the start of your investigation, what was your focus?
The start of the investigation was a preliminary assessment or canvass of the actual scene as to where the baby was found and located, any witnesses that were on scene, and subsequently interview any witnesses that were present still.
Were you involved in the interviews of the first few witnesses that testified in this trial, April, Hector, and Michael?
I conducted field interviews that same night.
And in relation to the same, you're on permission to approach the reporter for purposes of retrieving the exhibits that
You
shows.
may.
To be clear, when we're talking about the scene that you went to, I'm going to permission to approach the witness.
Okay.
I'm approaching the witness with what's been entered into evidence as Exhibit 15.
Yes, sir.
Is this the scene that you're referring to?
That is correct. That is the back portion of business, in this case being the Broadmoor Mall located at 1401 North Center.
And Your Honor, permission just for old-fashioned publication, since the jury's seen this exhibit, just to hold up what I have in my hand.
You may, it's in evidence.
And do you see the dumpster that is depicted in Exhibit 15?
I do, yes, sir.
What, if anything, was the significance of that dumpster in relation to your investigation in this case?
That is where the infant was located.
So you've discussed a little bit the scene that you went to, the folks that you interviewed on scene. At any point, did you shift your investigation to identify the perpetrator of this baby being in the dumpster?
Yes, given we located cameras nearby, which seemed to be pointing towards those trash bins or dumpsters, we went ahead and made contact with that business owner, which was later identified as Mr. Joseph Imbriali. He's the owner of Rig Outfitters, who was kind enough to give us access that same night to his camera system. We then went inside the business, we reviewed the footage, backtracked of course as to finding out who and when this baby had been dumped inside that dumpster. We then noticed that at approximately 1400 hours, approximately 2 p.m., that is when a white and colored vehicle approached the dumpsters and a female driver was seen exiting the vehicle. She then opened the rear driver's side door of that four-door vehicle and grabbed what appeared to be a black bag. She then proceeded to toss that black bag inside that dumpster and drive away shortly. As she was driving away, we were able to get another camera angle. There was a total of 2 cameras that were located that were pointing towards those dumpsters. And we then observed what appeared to be a partial license plate reading off of what the state of New Mexico calls a chili plate. It's a black background with a yellow trim license plate. It's got 2 chilies on it, followed by the numericals, which in this case were AXM S, followed by the numbers 6, 7.
Detective, let me just stop you there.
Yes.
Do you recognize what's been entered into evidence as Exhibit 11?
That is correct. That's the vehicle in question.
Was this the vehicle that was depicted in the video that you learned during the course of your investigation?
It was the same vehicle, yes.
And this is the Exhibit 11 that I'm referring to, Your Honor. I'm just holding it up for the jury because this exhibit has been shown before. Detective, when you reference the video that you observed from the Rig Outfitter store, are those the videos that the jury and yourself have already seen published?
Oh, that's correct. Yes.
You've also heard the testimony about the recovery of this vehicle and the seizure of the vehicle. What, if anything, as a result of that, developed your investigation to identify the perpetrator of this crime?
After obtaining that partial license plate, we did conduct a search, or what we call a query. Given we had the vehicle color and a possible make, we went ahead and conducted that search. One of those results was that of a 2016 Volkswagen Jetta with the registered address of 809 West McKenzie. After learning said address, we then proceeded to that address to attempt to locate that vehicle. Also, with those particular identifiers or unique identifiers, with that hubcap missing in the rear driver's side of that vehicle, we were able to confirm that that was the vehicle in question, recovered that same night.
After you had the vehicle, did it correspond to an address?
It did. It was registered to Martha Avila.
What was the address that the registration was?
809 West McKenzie.
At any point, did you interview the residents of that house?
I'm sorry, can you repeat the question?
At any point were you involved in the interviews of the occupants of the 809 McKenzie house?
Yes, after we did locate the vehicle in question, I along officers on scene, proceeded to the front door of the residence where we made contact with the defendant's parents, which were identified as Mr. Domingo Avila and Martha Avila.
At any point during the course of your investigation, did you identify the person who was seen in the video throwing the baby, the newborn, in the bag into the dumpster?
Yes, not only did we ascertain from the defendant's own parents who was known to drive that.
And we'll just take it one step at a time so that instead of what anyone may have said, just with reference to the question of were you able to identify the person observed throwing the bag with the newborn inside of it into the dumpster?
I did. She was identified as Alexis Avila, date of birth of 12/22/2003.
At any point, were you able to also participate in the recovery of a phone from Ms. Avila?
Yes, her phone was recovered at a later time.
Were you able to review the contents of that phone?
That is correct.
Were you able to learn any evidence from that phone?
Objection, leading.
Overruled.
Were you able to learn any evidence that she worked with anyone else to commit what we see in the video?
No.
And with reference to that phone, did you find any explanation as to why she would have done what we see in the video?
No.
And just to make sure that we're talking about the same person, so you've used the term Alexis Avila as the person that is observed in the video. Is this person, Ms. Avila, present in the courtroom today?
Yes, she is, to my right.
Could you identify her by an article of clothing and point her out with your finger?
She's wearing a tan coat with a brown shirt or blouse.
Your Honor, may the record reflect that the witness has identified the defendant?
So reflected.
At any point, and just to be clear, when we're talking about the phone and the vehicle, did you read the affiant for search warrants in order to acquire that information?
Yes, I was the one who authored and drafted those search warrants.
Did you require a warrant for the video that you acquired?
The video from the rig outfitters?
Correct, sir.
I did not. I was granted consent by that property owner.
And with reference to the plate and the search for the vehicle, what databases, if any, did you use to identify the vehicle involved?
What databases do?
Yeah, how is it that you were able to correspond the plate, partial plate on the vehicle to that residence, the McKenzie address?
Again, given we had that partial license plate number of AXM, that's when we conducted that search of a possible vehicle. And the results were that of a 2016 Volkswagen Jetta.
Now, at any point, did you conduct a interview with Ms. Avila, the defendant?
I did that same night at approximately 11:30 p.m.
Prior to asking her any questions about what you saw in the video, did you advise her of her Miranda rights?
Yes, only because I did have real evidence, in this case being video evidence of said crime.
And with reference to the rights that you advised her, did you advise her of her right to an attorney?
I did, yes, sir.
Did you advise her of her right to remain silent?
I did, yes, sir.
And did you go through the full colloquy of what you advised for purposes of Miranda?
I did, yes, sir.
And after you provided those advisory rights, did Ms. Avila agree to speak with you?
She did, yes, sir.
Was that interview recorded by any means?
It was both my department-issued body camera and that interview room camera, interview room number 3.
Now, with reference to your interview of Ms. Avila, Your Honor, permission to approach the witness with what will be pre-marked as State's Exhibit 1?
You may.
Yes. Now, I've just affixed a sticker to it. Do you recognize this USB, sir?
I did, yes.
And what do you recognize it
To be containing that video content or interview that I conducted that same day.
And for purposes of the portions of the interview where you're asking questions in relation to this case, are the contents of this drive a fair and accurate representation of the questions that you asked and the answers that you received from Ms. Avila on that day?
Yes, sir.
Your Honor, at this time the State moves for the admission of Exhibit 1.
Your Honor, we'll ask for further foundation upon opening the video and it still show the first time.
I'm going to conditionally admit it. You may show the beginning of it. If he says that's the interview, then it will be received.
Yes, sir.
Without condition.
Sir, do you recognize these first 2 seconds of the interview that you conducted?
I do, yes, sir. That's actually a view of my department-issued body camera. It's a cell phone-sized type of camera worn around my neck via lanyard.
Now, you referenced that there were 2 videos. Did I hear you correctly?
That is correct.
Does your lapel fairly and accurately represent the contents of your interview with Ms. Avila?
It does, yes, sir.
Your Honor, at this time the State moves again for the admission of this.
State's Exhibit 1 is received without condition and may be published.
Thank you, Your Honor.
I'm Daniel Bez, I'm an investigator here at the hospital's department. Alright, what's your name? Alexis, what's your full name? Okay, what's your date of birth, Alexis? 12/22/03? perfect. So before I do ask any questions, okay, I do per policy and procedure, I read everybody their rights. It doesn't mean anything other than me making you aware of your rights and you understanding your rights. Does that make any sense? Okay. Do you need any medical attention though before we start? No? Are you okay? Okay, you know what day of the week it is and stuff? Today, Friday? Okay. Alright, so there are bulletins. I'm going to read you each bulletin. If you have any questions, you feel free to stop me at any point, okay? So, of course, you have the right to remain silent. You do not have to say anything at all. And anything you do say can be used against you in court of law. Do you understand that part? Alright. Second bulletin, you have the right to an attorney before you talk to me, and you do have the right to talk to an attorney if you so desire. You understand that part? Alright. If you cannot pay for an attorney, the judge will appoint one for you free if you desire an attorney. You understand? Alright. You have the right to have your attorney present when I talk to you. You understand that part? Okay, and lastly, you do not have to talk to me, but if you do, you have the right to stop talking at any time. Okay? So today, let me just get the date. Sorry. Right, so approximately 11:30, okay? So 7th day of January 2022, approximately 11:30 p.m. So if you're willing to speak with me, you can initial all these bulletins that you understood your rights and print sign, and it's going to ask you at the bottom if you so want to talk to me or not, okay? If you wish to talk to me or not, if you can just initial yes or no. Okay. I'll put this out of the way. Alright, so I know there's a lot, okay, to talk about, and I just want to ask you, you know, why you think you're here, or what led us to us being here. Alright, obviously I do know information, and the last thing I want to do is, to start off on the wrong foot and for you to start, lying to. There's always two sides to the story. Obviously I'm looking at a evidence standpoint, what we were called out to. I don't know what you're going through, if you're going through anything, we're all humans. Before me being a detective, I'm a father, I'm a son and stuff like that. We're all human. It doesn't matter what rank we have or how old we are. Alright, and that's why, I asked you to come out here and give me your side of the story. Okay, I'm not here to judge you, I'm not here to question you, I'm not here to accuse you, I'm not here to, belittle you. That's not what I do, that's not my job. So my job is to investigate, and that's exactly what I'm doing. Alright, so if you can, I would kindly ask you just to tell me the truth and we'll go from there, okay? So you want to tell me what's going on, or what happened today, or what led to this? Right. Okay. So obviously I got confirmation that you were pregnant, okay? Right, you found that out yesterday? Okay. So tell me a little bit more about that. So how is that you found out, or how?
Well, I've been having back pain really bad, and I got in an accident September of 2020.
Okay.
And I just thought that's what it was. And I mean, the pain comes and goes, and so I didn't really think anything much of it. And it just kept hurting, and so my mom took me to the ER, and they just said that I had some kind of spray, I don't know what kind it was. And they just gave me medicine for it, and it wasn't helping.
Okay.
But I still didn't think anything much of it. I gave them my urine sample to see if for infection or anything.
Mhm.
There was nothing I guess. And then I just kept hurting, and so I went to the clinic and they did a urine sample and they told me I was pregnant, and that's what they found.
You said it was yesterday?
It's true.
And where did you go? What clinic? What hospital?
The one in Del Paso.
Del Paso? Okay, which one? Lee?
Yeah,
Okay,
the one.
alright. Who took you?
Myself, my parents were out.
Your parents were at work? Okay. So I believe your mom said that she had accompanied you, or she took you, or she went with you?
No, she didn't.
Okay,
I went by myself.
alright. So as I mentioned to you before anything, I like to speak, with the truth. Obviously, okay, I spoke to some people, and I know that back in March, is when you spoke to some people and you told them that you were pregnant. So you had prior knowledge, all right? So I'm not gonna,
Back in March.
right, somebody by the name of Walker, do you know anybody, a friend of yours, a school friend of yours that I spoke with, and she's the one that told me that you knew that you were pregnant and that you did not want the child? Mhm. Her mom is a nurse at the hospital. She was a friend of yours. You don't know anybody by that name? No? Okay. Well, that's her mom's last name. But I spoke with her, and she's the one that told me, obviously, that you knew or had prior knowledge. All right? Like I said, if you gotta be straightforward with me, okay? Okay. So, anyway, explain to me as far as what happened today. How did your day start today?
The same as any other day. Well, it's the same for the past couple of days.
Okay.
'Cause I was in pain. I just thought I was, I'm sorry.
It's okay. I know there's a lot. I understand there is a lot going on.
Where you can't poop.
Okay. Constipation?
Yeah, I just thought that's what it was.
Okay, so you.
It was hoping go to sleep and then go back to the restroom. Go to sleep and go back to the restroom.
Okay. So what time did your day start?
I couldn't tell you, to be honest.
Okay. So you don't know what time you woke up, or are you working? Do you go to school?
I go to school, but I haven't been to school.
You haven't been to school?
I didn't work today.
Okay. Where are you working on?
Marketing.
Okay. So you haven't been going to school this whole week? No? Because you've been sick, or? Okay. So you don't know what time you woke up. Obviously a lot happened, okay? So I just want to get a time frame as far as, okay, you don't know what time you wake up, but you woke up at your parents' house where you live? What's your address? Okay. You woke up there, you live with your parents? Okay. What did you do when you woke up? Okay.
I was in pain. I was up all night going down to sleep and I go to the restroom. All I was in my all day today.
Okay. So what happened after you started going to the restroom?
I just went back to sleep because I couldn't go.
Okay. And then after that, what did she do?
Working.
Yeah, I mean, obviously
It was repetitive. And then my dad went to the store and got me some pills. I don't know what to do. They were supposed to have me food. And I took it and I went back to sleep. And I stayed asleep for I don't even know how long.
Okay.
And then I woke up and I just kept trying to use the restroom and I'd go back to sleep.
And what happened after that? So obviously, I mean, you and I know what happened. I mean, obviously.
Yeah, but like I can't tell you if you like I'm not really good explanation.
Okay. So obviously you gave birth to a child. I'm trying to find out where it happened, how it happened, or what led to that and stuff like that.
I went to sleep and then I woke up and I went to the restroom and I was just trying and then it came out and I thought it was poop and then
Okay. So you were where? And you're at your house?
Yeah, I was by
Okay.
myself.
You're by yourself?
Yes.
Okay. I mean, that's not normal, right?
Right.
Okay, what happened after that?
I was in a panic. I didn't know what to do.
Okay.
I was scared.
Okay. What did you do after?
I cleaned myself and I just left it where it was, and I was scared. I was trying to call my mom, I couldn't. I was so scared. I think she was gonna hate me.
Okay. What made you think that?
Just because I just turned 18. I haven't been 18 for a month. And I'm the baby.
Right. I understand that's a lot to take, okay, and that's why I'm here, getting your side of the story. You're home alone, or who was in it? You were by yourself? Okay, and this happened where? In the restroom? Your restroom? You guys have separate restrooms? You have?
There's one restroom.
There's one restroom? Okay. What did you do after the fact? Or what happened? I mean, obviously.
Like I was just cleaning. I was scared. I didn't know what to do.
Okay.
And I just wrapped it in a towel.
Okay. Did you ever thought of contacting, you know, an ambulance, a fire department to go out there and check you out?
I didn't know what to do.
Okay, scared of what exactly?
The baby had, like it was nowhere.
Right, but you're telling me that you knew yesterday, right?
Yeah, but I didn't know it was, I didn't know how, and I didn't know nothing.
Mm-hmm.
I knew, but I didn't like know it was coming today.
Right. So it was unexpected.
Right.
You weren't expecting it to happen. Did you contact anybody?
No,
Okay, you said you contacted your mom?
no, I tried, but I couldn't, I was scared.
Mm-hmm. Okay, so there's a difference between being scared. I mean, I understand you're young, you don't know, obviously, but if both you and I know that pregnancies, you know, they're pretty obvious. Your stomach starts growing, you know, you got several different symptoms and stuff like that. Right.
I didn't have
Okay.
I was gaining weight, I was eating more, I was, nothing changed.
Mm-hmm. So you're in the restroom, you give birth, you wrap it into a towel. What is that? Your towel? What color towel?
I don't even remember,
You don't
to be
remember?
honest.
Okay, so what was your next act? What else did you do after that?
I just left and I drove around and I just put it to where I put it.
Okay, where are we talking about? Put it where? I mean, obviously I know where you went, and you didn't put.
Right, like I had the trash bag in the car.
Okay.
Like you couldn't tell the car was messy,
Mm-hmm.
but I put it.
So.
I put it in the bag. I took it to the car. When I was in the car, I had 2 trash bags.
Okay.
I took one with me, which is the one that I had,
Mm-hmm.
and then I put it again, and then I drove around and I didn't know what to do, and I just put it in there.
Okay. Where did you go? Where did you drive to?
JCPenney's. I was in that area. I live in that area.
Mm-hmm. So where did you throw the garbage bag? In trash. Okay, did you lock it up, seal it up?
With the hair tie.
I'm sorry?
With the hair tie.
With the hair tie?
But I don't even think it stuck because it was broke.
Okay. So you
I was
just,
on the verge of breaking.
okay, were you by yourself in the car?
I was by myself the whole time.
Okay. You never notified anybody?
Mhm.
Okay. So you grabbed your hair tie and just wrapped it around the bag? Both bags? Or
No, just, well, I guess, yeah.
what color was the bag? The black bag. So you put the hair tie around the black bag? Alright.
I
So,
don't even think it stayed, to be honest. Like I said, it was broke. Like it
mhm.
was on the verge of breaking.
Alright, did you place it there? Did you throw it there? What did you do?
What do you mean?
I mean, the trash
The
can.
trash, I just, when I tossed it.
Was it a normal trash can, like one of those that they pick up, the city picks up, or a bigger trash can, or what?
The bigger trash can.
Well, what kind of trash can were we talking about? There's different. Okay. What color was the trash can? So you just went and placed it inside or outside or? Alrighty. So obviously you're 18 years of age. You know right from wrong, right?
Right.
Okay. So you wrap around a newborn inside a trash bag.
I'm
Right.
just turned 18.
Right.
Like I've been 18 forever.
Exactly. But you know, I mean, if somebody were to wrap you inside a trash can and put a tie on it and you're not able to move.
Well, the tie was broke. Like
Right.
I would be able to stick my hand in there.
What do you think would have happened?
What do you mean?
So what do you think would have happened? You never notified law enforcement. You never called for EMS. You never.
And by then I was still angry.
What exactly? What do you think was going to happen?
I don't know.
You don't know what would have happened.
Well, I mean, obviously I know, but
Mm-hmm.
and I'm in a panic. There's a baby in front of me. I just
Okay. You never notified your mom?
never.
No, you never notified anybody.
Nobody.
Okay, so it's not, it's not normal behavior from any reasonable person to do what you did. If I'm, it's not.
I'm in a panic when I just turned 18.
Right. It still isn't though. We're talking about a baby. We're
I
talking
know
about a
what
kid.
you mean, but like,
Okay. Let me take a small break, okay? Back to where we left off. I appreciate you, telling me what happened and stuff. What did you do after the fact? I know. What time more or less was it? Do you remember? Do you recall?
And I'm just going to pause the video at the 17-minute, 20-second mark for just a couple questions regarding Exhibit 1 and what we have on this. Sir, did you observe the break in the video?
I did, yes, sir.
Did you walk away at that point in time?
I did.
I take it necessarily you weren't asking questions regarding the substance of what we see on those videos while you were away from the room.
Right.
And then just to make sure that we're explaining this exhibit, the file that we're playing, what is the title of it?
Interview redactable.
Does it contain both portions, containing the entirety of your interactions regarding the substance of this case?
It does, yes, sir.
And then for these two other files, are those just separate portions of the video with that cut, obviously?
That is correct.
And so, if I understand you correctly, is the entire substance of your interview in the file entitled full at the bottom?
It is, yes, sir.
For lack of a better term, the first two are repeats, just separate files.
Yes, sir.
Okay. Your Honor, may I continue with the publication?
You may.
Like 2:15 maybe, somewhere around that time.
Okay, that's when you dropped off the baby?
Somewhere, I believe so.
Okay, what did you do after the fact?
I drove around to drive around.
Continue to drive around? To do what?
Just, I don't know, just to clear to figure out what to do.
Okay. What else? I mean, where'd you go? Where'd you end up going? What did you do?
I ended up going to my house.
You ended up going to your house? What did you do after?
When I went to my
Mhm.
house, I just sat on my bed and I was trying to figure out
Okay.
what I was supposed to do or what to do.
At any point, did you make anybody aware of it?
No, I was still in shock.
Okay. Nobody found out? Nobody knew about it? Okay. Were your parents back home at the time? You were home alone? Okay. Did you seek any medical attention or no? Did you think about, what could have happened or what, could end up happening to the baby?
Yeah.
Okay.
I went to his like, is it okay?
Okay. They'll be briefing me here as we go, so last I heard the baby's okay. Okay. So, did it ever cross your mind to let anybody know, contact law enforcement, go back?
I didn't know.
Okay.
I'm still in shock the whole time when my friends got home. They just didn't tell them I was still in shock. I was in my room.
You're in your room. Okay. Did you ever leave the home afterwards? Did you go anywhere? Did you talk to your parents when they got home?
Yeah, eventually, but I didn't say anything.
Mm-hmm. So your parents had no knowledge.
No knowledge, absolutely.
And what if I were to tell you that they did have knowledge? Or they told me that you did know about it? What would you say then?
How? Because I didn't even know.
Okay. You didn't know, but yesterday you found out?
I mean, what do you mean? Because I feel like we're talking about two different things, and it's not going well.
We're talking about a baby that was thrown in the trash like garbage, right? And it's a human being. That's what we're talking about.
When my knowledge, when they found out, was when the officer showed up at my house.
Okay. So I'm talking about the knowledge of you being pregnant, obviously.
Oh.
Because I know that you knew back when you found out you were pregnant, and it wasn't yesterday. That's what I know. Okay, I don't, like I said, I don't go that route, but I know, and I do my investigation prior to even talking to you, and coming out here and interviewing you. Okay, as I told you, I'm not here to judge you. There's two sides to the story, but if you're gonna come and tell me that you found out you were pregnant yesterday, and I know that's a lie, then
Sorry.
go ahead.
No, go ahead.
Then it changes things because I don't appreciate that.
You're right. I found out I was pregnant yesterday.
Okay.
Like, I heard it. The doctor showed me. I knew back in whenever, but I didn't know. Does that make sense? Like, I was like, oh, it's whatever.
So you knew back when is this? What are we talking about?
Back in August,
Okay.
maybe a little bit before that.
All right. So yesterday, whenever you went to the doctor, how far along did they tell you were?
They didn't say.
They didn't tell you? Okay. So.
That's how I didn't know it was coming today.
All right. So obviously, I'm not a girl. I'm a guy, but I know women have menstrual periods. So how can you not know?
I have my menstrual period every month.
Okay. So that never changed.
Never.
So, but you knew back in August.
I took two. One was positive, one was negative. I took the negative. I didn't.
Okay. What about, as far as you, the gaining weight, any movement, anything like that?
Listen.
Okay. So, back in June, you had an incident, I guess you ran away from home? Were you having...
I guess you could say ran away.
Okay, was it a result of this? I mean, were you having problems with...
It was a completely different matter.
Okay. So is this the father of your baby, the person you were having issues with? Or you were sending messages to your mom, suicidal messages, saying that you were going to be with God, and cops were called out to your address in June. Is it, does this have to do, to me, it obviously...
It has nothing to do with him.
Okay. This is not the person that is responsible for your baby, or... I know this is a lot of questions I'm asking, I'm just trying to figure out, like I said, I'm not here to... Okay, so it's not a result of this.
He had nothing to do, like...
Right. So it's not him. Is there somebody we need to talk to? I mean, did he do something to you
No.
that would lead to this? Did he, no?
No.
Okay, but you do know who is the father of the baby. Okay, but he did. Okay, do you mind sharing his name? Okay, Stephen Astorga? How do you spell the last name? Okay. Do you happen to know his date of birth by chance? You don't? Do you know more or less how old he is?
He's 16, 17.
Okay, 16 or 17? Y'all dated for how long?
About a year.
Okay. So I'm assuming you met in school?
Yes.
Do you mind me asking what happened, or what? Did y'all break up?
We broke up. We just,
You broke up.
Yeah.
Okay. When did y'all break up?
When?
Mm-hmm. You don't remember? More or less? A year ago?
August, I think.
Around August?
Yeah. Sometime like the beginning of school.
Okay. So you said things weren't working out? So obviously if you know enough for you to tell me that he's obviously the father of your child, you should have known when you got pregnant, right?
Honestly, not.
Not really. But you're able to tell me who it is, so you know a reasonable person would say that you knew when you got pregnant.
Not without the respect, not
No.
necessarily. Because I mean,
Okay. I'm just, putting it out there. You gave me information, obviously, but he didn't do anything as far as to lead you to do this? Nothing? Okay. Did you just think you would be better off without a child because you're too young?
no,
I mean,
sorry, go back.
I'm trying to reason as far as what,
Like what's in my head? Or like what?
I'm trying to reason your actions. That's what I'm trying to find out.
Oh.
Yeah, a reason behind your actions.
I knew I was too young, but I knew I would be able to do, like, I'm about to graduate school.
Mhm.
School's not my worry. I have a stable job. Money's not a worry for me.
Okay.
So I would be able to, like, if the baby's okay, I want it.
Okay. And what if I told you the baby was dead? What would change then? Alright. What's a good phone number we can reach you at?
575.
Mm-hmm.
Would I be able to give my mom's number, or do I have to give you mine to
Your phone number, yeah, your cell phone number.
7757.
Alright. And again, I'm gonna ask you, do you need any medical? I know you gave birth, obviously. It's not something normal. It's not something you do every day. Do you need us to call an ambulance out here? I mean, my worry is your well-being, obviously.
I don't feel the need, but
I mean, you're 18 years of age. If anything, you can at least get checked out. It's up to you.
would my mom be able to take me?
Yeah, it's completely up to you. I mean, I'm just asking you right now if you need somebody to come check you out right now.
I prefer not here.
Okay.
So maybe my mom could take me somewhere.
Okay. Perfect. Let me just take one last break and I'll be right back, okay?
All right, that concludes Exhibit 1. Detective, my final series of questions is just in relation to a timeline of the course of your investigation. So starting first with, when did you first receive your assignment?
That same night, I was contacted by Sergeant McKean.
Was that January 7th of 2022?
January 7th, 2022, yes, sir.
And then what approximate time was it that you were able to make it to the scene?
I made it to the scene, I want to say maybe 20 minutes after I was contacted.
About what time of day was that?
It was approximately 8 p.m.
When you made it to the scene, what were the conditions at that point in time?
It was dark. It was a cold night. As you can tell in my interview, I was wearing a jacket. It's got a double sleeve. And that's how I showed up on scene, because it was a cold night.
Was the coldness of that January night usual or unusual for that week and time of year?
It's usual only because, again, it's January, so wintertime.
Now, you mentioned that you interviewed certain witnesses. I take it that was around the time that you were at the scene?
Yes, as soon as I got to the scene, I was informed by officers as to who who had discovered the baby and how many people were still on scene.
At what time, for purposes of Exhibit 1 that we've seen, about what time did that happen?
Did I start my interview process?
Correct, with Ms. Avila.
Oh, with Ms. Avila. I met her, or she met me at the House Police Department, 300 North Turner, at approximately 11:30 p.m.
You've testified previously to a search warrant for the vehicle. When was that executed?
That search warrant was executed the following day, January 8th, approximately.
Did you ever execute a warrant on the McKenzie address?
I did.
And just to make sure that we're speaking with reference to the things that you discovered there, Your Honor, permission to show the witness Exhibit 31.
You may.
Do you recognize what I'm showing you, Exhibit 31?
I do, yes, sir.
Okay, and what is it? Is this from, was this the scene that you saw during the execution of the warrant that happened?
Yes, that's correct. More specifically, inside the restroom, and those are the contents of the trash can, which I dumped out and photographed.
And when you're talking about the contents of the trash can that were photographed and taken out, I'm showing the witness what was entered into evidence as 18.
Yes, I recall.
And to be clear, you actually did recover the trash bag, is that correct, sir?
We did, yes, sir.
And to make sure that we're following the reference for the course of your investigation, you assisted one of the witnesses earlier in the trial with presenting the contents of this bag, is that correct?
I did, yes, sir.
And are the contents of the bag what was photographed in that picture?
Yes, sir.
Did this appear to you to be the bag that this baby was inside of when he strapped it to the dumpster?
It was, yes, sir.
For the recovery of the defendant's phone, approximately what time did that happen?
That occurred on January 22nd at approximately 12:55 hours.
Would it be fair to say that you were gathering evidence from the 22nd all the way back to when you were assigned this case on January 7th?
That is correct, to include an interview that was conducted of Stephen Astori.
At any point, did you ever meet with the victim in this case, the newborn baby?
I did. After I was done processing and canvassing the scene and collecting whatever evidence, and after I conducted those field interviews on April, Michael, and Hector, I responded back to the hospital only because we did not know if the baby was still, of course, alive and what the outcome may have been. So we proceeded to the hospital and obtained some photographs of him.
Detective, during your interview with the defendant, she mentioned 2 pregnancy tests in August. Do you recall hearing that during the course of your interview?
I do recall.
One of them was positive, the other was negative.
According to her statement, yes, sir.
At any time, were you able to recover the positive or negative pregnancy test results?
No, sir. No, sir.
And to make sure we're clear with reference to the timeline, approximately how many months are between August and January 7th that you were assigned this case?
Approximately 5 months.
I'm showing the witness what's been entered into evidence as Exhibit 6. Sir, do you recognize the newborn in this picture?
I do.
And when you asked the defendant about whether she knew what would happen and said, well, obviously, I know, was that statement in relation to this baby as you understood it?
That's correct.
Your Honor, the state passes the witness.
Cross-examine.
Yes,
Ms. Adipoti.
Good morning, Detective.
Good morning, ma'am.
Detective, on that night of January 7th of 2022, you or some officers from your department went to the household of the Avilas, correct?
Well, that is correct, yes, ma'am.
And Alexis was subsequently brought to you for an interview, correct?
She agreed to meet with me, yes, ma'am.
So she did meet with you for an interview?
She did, yes, ma'am.
Okay. Because we just saw a whole video about that, correct?
That's correct.
Okay. So you gave her Miranda advisory, correct?
I did, yes, ma'am.
You read her rights,
Correct.
the first one being the right to remain silent.
Correct.
And that means she did not have to talk to you, did she?
Correct.
She had the constitutional right to choose to not say anything to you.
That is correct.
She could have chosen not to answer any of your questions that night.
Yes, ma'am.
But she did not make that choice, did she?
No, ma'am.
She signed off all the documents you gave her.
Each bulletin, yes.
She initialed next to each one, or was it a signature?
I'm sorry?
Was it a signature or an initial
An initial next to the bulletins and I believe a signature down
at the
below.
bottom? In fact, as she's initialing, she gets to the end and she goes, where else do I sign?
Correct.
And then she signed,
Yes, ma'am.
indicating that she was willing to talk to you
Correct.
and she was willing to answer your questions.
Correct.
In fact, she said to you, I don't really know how to talk much, so just ask me questions.
Correct.
So you proceeded to ask her questions,
I did.
and she answered them.
Not truthfully, but yes.
But she answered your questions.
She answered some questions, yes.
And you said not truthfully, and that is based on the information you indicated you had at the time, correct?
Correct.
Including a statement saying that she was pregnant in March. Is that correct?
Correct.
But we all know that she had the baby on January 7th. Isn't that right?
Correct.
Which would make March, I don't know, a little over 9 months before. Is that not correct?
Correct.
So she did answer your questions.
She did.
Okay. And so your indication that she was not truthful was at least not based on that information.
No.
Okay. And so this information you said you gathered from somebody, right?
Yes, ma'am.
Somebody else had told you that.
Correct.
Maybe a kid from school?
No.
No, not a kid from school?
No.
A family member of a kid from school?
No, it was an officer who had informed me of that information.
Where did the officer get that information from?
From the hospital staff member
Where did they get that information?
that same night.
Where did they get that information?
Who she spoke with, I do not know.
You do not know.
I don't.
You've never attempted to find out where that information came from?
After realizing, as you just stated, as to when she would have found out she was pregnant, it was not pertinent for me to follow that lead.
So you knew that information was wrong?
After I did the math, yes.
Okay. So as you're interviewing her, she thought she had constipation.
That's correct.
And she also told you that she was employed?
Prior to telling me she had constipation, she stated she had back problems, and she was employed, yes.
She said she had something was wrong, where you can't go to poop,
Constipation, yes, ma'am.
and you said it was constipation.
Correct.
Okay, so she told you she had constipation,
Correct.
or at least she thought she did.
Correct.
Okay. And she told you she had a job.
She did.
She told you she went to school,
She did.
high school.
Correct.
She told you she hadn't gone to school that day.
Correct.
She told you that she lived in her parents' house.
She did.
She told you she lived there with both her parents.
She did.
And on that day, they were not home when this happened.
Correct.
She told you her dad had come back from work at some point that day.
Correct.
He had given her some pills
Correct.
for constipation,
Right.
but he wasn't there when she had the baby.
Correct.
Her mother was not there when she had the baby.
Correct.
She told you she panicked.
She did.
She said she was scared.
She did.
And she repeated again at some point in the interview that she's not very good at explaining these things.
She did.
She said she was scared. She just started cleaning after it happened.
Correct.
She said she didn't know what to do.
Correct.
She said she wrapped the baby in a towel.
Yes, ma'am.
She said she didn't know that she was pregnant.
Correct.
And then she said, I knew, but I didn't really know, right?
That's correct.
She told you about 2 tests that she took
Right.
in August,
Yes, ma'am.
5 months before.
Correct.
She said one was positive and one was negative.
Correct.
In August of 2022, she was 17 years old, correct?
That's correct.
Because she had a birthday in December 22nd, you told us that.
Yes, ma'am.
So December 22nd, she turned 18.
Right.
And then 2 weeks after, January 7th, she has a baby
Correct.
in the bathroom,
According to her, yes.
according to her.
Yes, ma'am.
Do you have contrary information?
No, I'm stating the obvious.
Okay. So she had a baby in the bathroom.
Correct.
Her parents were not there.
No, ma'am.
And you asked her, and she told you there was no emergency help. She did not call for help.
Correct.
So there were no medics to assist her with this birth.
Correct.
She just had a baby.
Correct.
You did indicate that you have children, correct?
Yes, ma'am.
Did you see them born
Yes.
in a hospital
Correct.
with medical attention,
Yes.
and they were properly cared for?
Correct.
Umbilical cord was probably cut just right
Right.
with the proper equipment?
Yes, ma'am.
But that's not what happened with Alexis, was it?
No.
And so she panics, she says, right?
Yes, ma'am.
She wrapped the baby in a towel.
Correct.
She put the baby in a trash bag.
Correct.
Now, the state showed you a photo of a trash bag a trash bin that you flipped over the next day. Is that right?
The menstrual pads photo?
Yes.
Yes.
Okay, so that menstrual pad photo was not in that bathroom on the 7th, as far as you know.
Well, I have no way to prove because that search warrant was executed, as you mentioned, on January
On the 8th.
8th. Correct.
So the trash bag in which the baby was found is not the one that had the bloody mess in it with all the used pads and things like that. Is that right?
The baby was located inside a dumpster, and those menstrual pads were located at her residence, 809 West Main.
So they don't even connect.
They don't.
Okay, just wanted to be clear because the photos, just wanted to make sure. Okay, so this baby is in a towel in the trash bag.
Correct.
And she said, I just drove.
Right.
She was just driving.
Correct.
Let's talk about the tie that she put on it. She said she put a hair tie on it. She told you that, correct?
She did, correct.
So you were the one in charge of this entire investigation. Did you find the hair tie?
But we did not locate a hair tie.
You did not locate it on the bag where the baby was found?
We did not.
What about in the rest of that dumpster? Was it in there?
Not that we could tell.
You couldn't tell. But it was not on that bag.
It was not inside the bag or on the bag.
So she said, I put a hair tie. I don't think it stayed.
Right.
It broke.
That I don't know.
She said she thought it broke.
I can't testify to something that I did not witness. I don't know if it broke or if it didn't.
Okay, we're talking about what you've testified to, which is everything she told you, pretty much, right?
That was her statement to me, yes.
That was her statement to you. Okay, and you don't have any information to the contrary, do you?
Correct.
Okay. And then during your interview of her, you said to her that you talked to her mother, right?
Yes, ma'am.
And you said her mother knew.
Correct.
But your officers had just informed her mother that night. Is that not correct?
Yes, including myself, we went and I made contact with both of her parents that same night.
And then there was conversation about her going to the hospital, right?
Correct.
And at one point she said that her mother took her to the hospital. Remember that?
I do, yes.
And then at another point, she said that she went to the hospital herself, remember that?
Correct.
And you now know that she did indeed actually go to the hospital twice before January 7th, leading up to January 7th.
Correct.
Is that not correct?
Correct.
And one time with her mother, one time without.
Correct.
And as you went on questioning her, she asked you, is the baby okay?
Correct.
She told you that if the baby's okay, she wants it.
Correct.
Now, previously, at a different hearing, you mentioned that she called the baby it. Is that not right?
That is correct.
And is that something that concerns you or not?
Of course.
Okay. And today in court, we saw the video, is the baby okay?
Right.
I didn't know what to do, it just came out.
Correct.
I wrapped it and I put it in a bag.
Correct.
I had a trash bag.
Correct.
I tossed it in the dumpster.
Correct.
In fact, today in court, several other people have addressed that baby saying it. Is that not correct?
I have not been here present, sitting down, so therefore I would not know.
Okay. And so if I told you that a previous testimony by a doctor who treated the baby addressed the baby in the same way, would that be surprising to you?
Yeah, well, given their relationship or non-relationship to the child, that's not surprising. Coming from its own mother, it is very surprising to this day.
Coming from its own mother?
Correct.
Its own mother. Okay. So, but she did say she wanted the baby if he's alive, right?
That is right.
Okay. You did some more investigation other than talk to Alexis, right?
I did.
And you obtained search warrants,
Yes.
several of them actually.
Correct.
And one of them was for a cell phone, you told us that, and a ring camera, right?
Correct.
So you collect that cell phone and there was an extraction done.
There was.
An extraction of a cell phone means you collect all the data from this cell phone. Is that not how that works?
Correct.
That is a lot of information, isn't it?
Correct.
Including text messages. Correct?
Correct.
Internet searches, maybe?
Correct.
Records of phone calls, maybe?
Correct.
And out of all this information, you did not find anything, any conversation in there that tells you that Alexis knew she was pregnant.
We did find messages.
You did find messages.
We did.
Okay. And so your testimony today is that you did find in her phone records messages.
Correct.
That is your testimony. Okay. That's all I asked you. You indicate what you did.
Okay.
Okay. The ring door camera.
Correct.
What kind of information did you gather from there?
There is no information gathered.
No information from there. Okay. Now, when you were testifying earlier, the state asked you, was there explanation on her phone as to what she did? And your answer was there wasn't. Isn't that correct?
That is correct.
Okay. So, you continue on, you find some information, you asked her about some communication about she was going to kill herself,
Correct.
and you found this information on her phone?
Yeah, that was on her previous involvements with the Hobbs Police Department, which a report was generated given set threats or.
And so that information, the police was called out because she made that threat.
That is correct.
Okay. You also obtained a warrant for her medical records. Is that not right?
That is correct.
And you did gather her medical records.
Correct.
How far back did you gather as with regards to medical records? How much information did you get?
That I don't recall.
Okay. Did you review that medical information?
Very briefly, only because some of the medical terms I'm not very familiar with, and I'm not a medical expert.
And that those medical records did not tell you that she was pregnant prior to January 6th.
One of those medical records indicated she was having contractions the day prior, January 6th.
The day prior, January 6th, correct?
Correct.
Okay. Now, during this search, when the warrants were being executed, the car and the home, right?
Right.
During this search, there were some documents also found.
Correct.
There were some documents from the hospital found.
Correct.
There was a document found from January 6th visit to the hospital.
Correct.
And those are the documents that she got from the hospital, correct?
Correct.
That was given to her,
Correct.
not the medical records that you had a warrant for and received from the hospital.
Correct.
So those are completely different documents.
They are.
And you saw the document that she had.
Correct.
In fact, one of those documents said she could return to work on the 7th, the very next day. Is that not correct?
I don't remember the specific date, but I remember.
Okay. Your Honor, may I approach the court reporter for exhibits?
You may.
Thank you. And Your Honor, may I approach the witness with what's been marked and entered as defense's exhibit B?
You may.
Is that one of the items that was photographed pursuant to your search warrant?
That is correct.
And does that item not say that she was allowed to return to work on the 7th of January? Or school?
Student will be able to return to school on January 5th, it reads.
Okay, in just a moment. May I approach the records keeper again?
You may.
Okay. I will now approach the witness with defense's exhibit B, previously entered into evidence. D, exhibit D.
All right.
Here. So exhibit B in front of you indicates a hospital visit from January 4th. Is that correct?
As per Exhibit B, yes.
And she was then allowed to go back to school on January 5th.
As per the school release form, yes.
All right. Now, what is being marked as Exhibit D indicates a hospital visit from January 6th, correct?
That is correct, according to this document.
And that document also says that she is allowed to return to work on January 7th, correct?
She may return to school on 1/7/22 according to this document, yes.
Okay. And we now know that on January 7th, she birthed a baby.
That is correct.
Okay. Your Honor, may I approach the retreat exhibits?
You may.
If I may have just a moment.
You may.
There will be no further questions. Thank you, Detective.
Take it out.
Redirect.
Yes, Your Honor. Detective, I'm going to work my way backwards through the cross-examination. First, you were shown Defense Exhibit D. I believe Your Honor, permission to retrieve the exhibit. The return to school note for the week that this newborn was born. Do you remember being asked questions regarding this exhibit
Yes,
by
sir.
defense counsel? During the course of that week, did you receive any information that in fact the defendant did return to school?
No, sir.
She denied going to school that week. Wouldn't that be fair to say?
According to her own statement, yes.
When you were asked questions with regards to essentially confronting Ms. Avila, the defendant, with where you were at the investigation, what is the purpose of that, if any, when you're conducting interviews with suspects?
What exactly are you trying to ask?
I'm speaking with reference to the questions that defense asked you about you confronting the defendant with statements from her mother, statements from some sort of walker that ended up being unverified.
Right.
What's the purpose of confronting a suspect in an interview with information you've acquired during the course of the investigation?
Those are different interview and interrogation tactics that we commonly use.
And when she was responding with reference to the walker and whether she in fact had previously been pregnant, did she ever give you what you felt to be a clear answer with regards to whether she had prior knowledge of her pregnancy?
No, she did not. If you notice, she did not answer my question as to her finding out or knowing that she was pregnant at the time, regardless of who I learned the information from.
Later in the interview, you heard statements like, I knew, but I didn't know. You heard information regarding the August positive and negative test. Would it be fair to say that you were acquiring information regarding her knowledge of pregnancy in a piecemeal fashion?
I was, definitely.
And you were also asked questions with regards to text messages on cross-examination regarding knowledge or some sort of alert that she was pregnant. Do you recall your answers to those questions?
Yes, my answer was yes.
And I'd like to refer your attention to what's been pre-marked as State's Exhibit 37 for purposes of foundation. I guess I'll ask you a couple additional questions. Would it be fair to say that the cell phone extraction was voluminous? There were a lot of text messages over time.
There was, yes, sir.
At any point, were you able to review the extraction for statements made by the defendant, Ms. Avila?
Yes, sir.
And when you answered on cross-examination about messages that were alerting Ms. Avila to pregnancy, I'm going to show you what's been pre-marked as Exhibit 37. May I approach the witness? Your Honor? Do you recognize the exhibit that I've handed to you, sir?
I do, yes, sir.
What do you recognize it to be?
Messages exchanged from her cell phone number being 575-318-7757 to a person by the name of Kimberly Avila.
And with reference to her statements and the statements that Ms. Avila was alerted to, when you answered on cross about some messages indicating pregnancy, are those messages contained in the exhibit that I handed to you?
They are, yes, sir.
And is that one of many messages that Ms. Avila had sent out over the period of time that you were able to get this extraction on?
That is correct.
Are those messages a fair and accurate representation of the messages that you were relying on when answering these questions on cross-examination?
Yes, sir.
Your Honor, this kind of state moves for the admission of Exhibit 37.
Any objection?
No objection.
State's Exhibit 37 is received into evidence and may be published.
May I retrieve the exhibit?
You may.
And just taking this in reverse order, so that we can understand the printout and how it operates.
is glitching. I don't really know what it's doing. So I'm just gonna close it out and start over.
All right. You want to stand while we're getting the technical difficulty, certainly not. Okay. All right. I've been advised, this did happen once before in another trial, and we have to disconnect the system and reconnect it, which takes 5 to 10 minutes. We're going to go ahead and take a break at this time. During the break, don't discuss the case. Don't allow anyone to discuss the case in your presence. Don't do any independent research about the case. Don't form any fixed opinions about the case until the case is finally submitted to you. Please stand for the jury. You may be seated. Court's in recess for, it's now approaching 11 o'clock till 10 after 11.
does that mean?
The text content.
And for the next part of the content, that yeah, apparently I'm pregnant. Who did you understand the originator or author of that message to be?
Alexis Avila.
December 14, 2021, but yeah, apparently I'm pregnant. Now, as we read these messages, the numbers appear 1378, 1379, 1380. Are you tracking those numbers that I'm reading out on this exhibit?
I am, yes, sir.
In which direction would one need to be reading these messages in order to know their order?
From bottom to top.
And so when you're saying from bottom to top, as I understand it, please correct me if I'm wrong, earlier messages will be at the bottom, and time and additional correspondence moves in this direction upwards.
That is correct.
And so in terms of that statement that, yeah, apparently I'm pregnant, if one were to look at the surrounding context for this exhibit, they would need to start at the last page, work their way up, and follow the thread of the conversation. Would that be fair to say?
That would be fair to say, yes, sir.
Okay. With reference to the prior testimony that you provided of Ms. Avila being alerted with this term pregnancy, do you see message 1391?
Not on the screen, no, sir. Now I can.
And who is the author of that message?
The author of that message is Kimberly Avila.
And what is the text of that message?
Content is, I will read as follows. Oh, so people think you're pregnant. Is Stephen saying that?
And who is the recipient of that message from Kimberly? Oh, so people think you're pregnant. Is Stephen saying that?
The recipient was Alexis Avila.
And what was Ms. Avila's, or did Ms. Avila have a response as you can read it in the text?
She did 2 minutes later, 3:08 p.m.
And what was her response?
The content of it I will read. It says, I'm assuming.
And then working back to the beginning of this exhibit. Is this the first message of Exhibit 37, 1399?
That is correct.
And what is the content of it?
Well, tell me why I'm pregnant.
And who is the originator or author of that message?
Alexis Avila.
What was the response, if any, from the other side of the transmission?
That was responsive WTF, commonly known as what the fuck.
And the next line, who, if anyone, to the best of your knowledge, was the author of that message?
Kimberly Avila.
And what was the content?
The question is asking by who?
1396, the responding text message, who was the author?
Alexis Avila.
And what is the text of that message?
IDK, commonly short for I don't know, LMAO, short for laugh my ass off. Followed by, I was eating last night with my friend and he asked me. And that's why I'm not playing softball.
And then there was a response by who?
By Kimberly Avila.
What was the text?
So you're pregnant.
Was there a follow-up text message?
Yes, by Kimberly Avila.
What was it?
Wait, hold on, start over.
Did Ms. Avila, the defendant, respond?
Yes.
What was her response?
But my friends that became Steven's friends asked me to. Like out of nowhere, they'll just walk up to me and ask, and then when I say, can you, walk up to me and ask, and then when I say WTF, again, short for what the fuck, no one asked why they asked, they said IDK, short for I don't know, you just look it and I thought you were, or something like, oh, it's just the way you're standing, or make up some lame ass excuse.
And then the following message.
No, I'm not pregnant, hell no.
What are these squares at the end of the message? Oh, excuse me.
Possible emojis.
And so with that context, I'm now looking at the bottom of page 2 of Exhibit 37. You've previously provided testimony about Kimberly saying, oh, so people think you're pregnant, Stephen saying that. And if one were to continue reading the exhibit, it would flow in this direction up until her final statement of the, yeah, apparently, or excuse me, the final statement that uses that term in 1379. But yeah, apparently I'm pregnant.
Correct.
Did you see any reference in the defendant's text communications, either in Exhibit 37 or elsewhere in the extraction, of Ms. Avila mentioning that positive pregnancy test from August that you previously testified to?
Yeah.
Did you see any reference in Ms. Avila's text messages with reference of the equivocal alert back in March of 2022 that she might be pregnant?
No.
Did you execute a warrant for medical records of Ms. Avila, Detective?
I did, yes, sir.
You're under permission to retrieve the exhibit. I'll alert the number of the exhibit once I see it.
You may.
And I retrieved Exhibit 32, entered into evidence. Do you recognize the Exhibit 32 that I have displayed on the projector?
Did you pull it down? Yes, sir.
Do you recognize, what do you recognize it to be?
I recognize it to be a medical record from Norley Hospital located at the 1600 block of North Main in Lovington, New Mexico.
Are you able to observe whether entered Exhibit 32 contains the list of medications that Ms. Avila was prescribed?
Yes.
Do you see any indication in this list of prescriptions of any Tylenol 3, codeine, or anything like that?
Yes.
Where? And let me zoom in because I'm frankly having problems reading it. What's this first medication?
Albuterol.
Do you understand that to be Tylenol 3 with codeine?
I'm not judge, Your Honor. This calls for speculation. This witness has there's no foundation laid that this witness can testify to just about anything in this report.
Sustained.
In this medical report that you obtained through your course of your investigation, did it contain any information that a layperson like you would understand would indicate a positive pregnancy test or a positive pregnancy outcome?
Yes.
In fact, is that indicated at the top of the third page
Top
of this
left corner.
bit of medical documentation?
Yes, sir. Top left corner.
With reference to the final page of entered Exhibit 32, is there any language that a layperson like yourself would understand to be a referral to the ER for further evaluation?
Yes, sir.
And what would it have been in reference to?
Labor contractions.
There are no further questions for this witness.
Any follow-up?
Yes, Your Honor, if I may.
You may.
Thank you. May I approach the report of the exhibit?
You may.
Okay, Detective, just the state showed you what was previously marked as State's Exhibit 32, and you indicated that there is language in there that indicates a positive pregnancy test, correct?
Correct.
Okay. All right. And please, for the record, tell us what date is on this document?
A visit date of 1/6 of 2022, January 6th, 2022.
The same date that Alexis told you that she was informed that she was pregnant, correct?
Correct.
Okay. And now let us go back briefly to the messages that the state presented, the text messages. Detective, do you understand sarcasm?
I do, yes, ma'am.
Right, and maybe commonly used among teenagers?
Correct.
Okay, adults too, but maybe more likely to be used by teenagers, right?
Correct.
A lot, okay. So, here's what I would like you to do. So we will go, this seems a little confusing sometimes, so I have to look at it a little harder, because we're going backwards, correct?
Right, from bottom to top.
Okay, we're going from bottom to top. And so, we're going to go here and start at, try not to confuse myself too much here. So this is 91, 92, 83, 84. So, okay, so if the order of the numbers on these messages are between message number 1383 and 1399, which will be the earliest message? I'm sorry, let me take that back. Between 1376, I'm going to set that on here so you can see. So you see that message 1376 up at the top?
I do, yes, ma'am.
Okay, and that is the first page of that exhibit, correct?
That is correct.
Okay, I'm gonna put the last page of the exhibit on there to show you the last number, so we know what sequence we're going in. So this is the last number here, 1399, is that right?
That is correct.
Okay, so. I'm gonna set this on here on that screen, and we're going to start here from, if we're gonna read this, do we start from the top or bottom? If we're gonna go in order.
From the bottom.
We start from the bottom, so that's 1383,
Correct.
and then we go back. Are you sure?
Yes, you go up. So if you notice the time stamp, the conversations were from 2:41 p.m. to 3:49 p.m.
Okay. Okay, so right on here, I have, at that timestamp 1383, I have 3:13 p.m. Is that right?
Correct, meaning that is not the beginning of said conversation.
That is not the beginning.
Yes.
Okay. Okay, so we want to start from the beginning, which was
Timestamp.
page 2 of the state's exhibit. I'm going to set that on here, and that has timestamp 241, right?
That's correct.
Okay, so this is the beginning of this conversation?
It is believed so, yes, ma'am.
Okay, and we've established that this conversation was between Alexis Avila and this person whose name's on here, Kimberly Avila,
That's correct.
correct? Okay, I'm trying to get my pen right, it's not working. So, this conversation starts on this page,
Right.
and then it continues on to this page. Sound about right?
Sounds right, given the timestamp.
All right, and then the last page would be this page, right?
Yes,
In this series.
correct.
Okay, all right, so. Okay, so here's what I would like for you to do. I crave the court's indulgence, if you may. I'm gonna read, the messages from Alexis Avila, and I want you to read back to me, Kimberly. Can we do that?
We can, yes, ma'am.
Okay, and we're just gonna read it like a conversation. How about that?
Okay.
Okay, so, but tell me why. I'm
Your
pregnant?
Honor, at this point, the state has to object to the form of us proceeding this way and that it inherently calls for speculation. This exhibit speaks for itself, so the best evidence objection as well. Naturally, whenever someone's reading a message, given that the gist of this is to look at things like intonation, the state does not believe this is appropriate to proceed this way.
With an understanding that I'll give you only so much leeway, I'll overrule the objection.
Thank you.
And the conversation should be read without any inflection one way or the other.
And Your Honor, if I may just note the exclamation points like question marks.
You can note those.
Thank you. I'm pregnant. I'm sorry, I'm gonna start over. But tell me why, comma, I'm pregnant, question mark.
WTF, short for what the fuck.
Okay. And the next message?
By who?
IDK, LMAO. I was eating last night with my friend and he asked me, comma, and that's why I'm not playing softball.
So you're pregnant.
And the next one?
I'm sorry, wait, hold on, start over.
But my friends that became Steven's friends asked me, like out of nowhere. They'll just walk up to me and ask. And then when I say WTF, no, and ask why they said, IDK, you just look it, and I thought you were. Or something like, oh, it's just the way you're standing, or make up some lame ass excuse. No, I'm not pregnant. Hell no.
No inflections.
My apologies, Your Honor. That will be from Kimberly, the next message.
Oh, so people think you're pregnant. Is Steven saying that?
I'm assuming. Question mark.
Tia.
But I'm not wrong. He has a girlfriend.
Yeah, I think so. I haven't seen her or even met her. That's what I overheard when my mom was talking to them.
Oh, so they know about her, question mark.
If it's the same one, IDK. I don't even know what she looks like, or if he is with one. That was a while back. Neck.
Like during Thanksgiving break?
Maybe TBH. I suck at remembering irrelevant crap. Like if it has to do with family, I don't even pay attention.
If that's the one you're talking about, no, it's not the same one, it's someone else.
Weak.
But yeah, apparently I'm pregnant. And I seen them last night.
That's cray.
Can you email us and ask if I can take my test early? Does that conclude that conversation?
That is correct.
Okay. Did you, detective, at any point communicate with a person named Kimberly Avila?
I did not.
In the course of your investigation, you attempt to get hold of her, talk to her?
I did not.
Okay. Your Honor, I have no further questions. Thank you.
Any follow-up from the state?
No, Your Honor, thank you.
Any questions of Detective Perez from the jury? All right, you may retake your seat.
Thank you, Your Honor.
Any further testimony from the state?
Your Honor, could we approach?
You may.
Feel like standing.
Any further testimony from the state?
The state rests.
All right, ladies and gentlemen of the jury, we'll need to take a break at this time. Once again, during the break, don't discuss the case. Don't allow anyone to discuss the case in your presence. Don't do any independent research about the case. Don't form any fixed opinions about the case until the case is finally submitted to you. I think what we'll do, it's 11:30. I think we'll go ahead and take our lunch break at this time. And I'll bring you back at 1 o'clock. And at that point, we'll continue with the trial. Please stand for the jury. You may be seated. We are now in open court. Now in the presence of the jury, the state is rested. Anything from the defendant?
Yes, Your Honor, defense does have a motion. May I approach the podium?
You may.
Your Honor, at this time, defense moves for a directed verdict on the sole count of child abuse resulting in great bodily harm. Your Honor, viewing the evidence in a light most favorable to the state, there's been insufficient evidence presented to sustain the state's burden as it relates to abuse of a child resulting in great bodily harm. The child abuse statute in and of itself encompasses many different types of harm. However, our legislature has differentiated those types of harm. Your Honor, the state has presented insufficient evidence to sustain the heightened burden required for great bodily harm. Our legislature has defined great bodily harm in New Mexico statutes annotated 30-1-12, paragraph 8, an injury to the person which creates a high probability of death or which causes serious disfigurement or which results in permanent or protracted loss or impairment of the function of any member or organ of the body. Your Honor, the state has presented many witnesses over the course of these 3 days. They have presented about 15 witnesses, about 5 of them were experts, Your Honor. Your Honor, just to recap the testimony we have heard testimony from Caleb Shearer, the EMS worker. We heard that he saw no physical injuries, but that he needed to warm up the child. We heard testimony from Jennifer Maxwell that she saw a small bruise. There was no indication that the bruise was life-threatening. Your Honor, none of the testimony from either of those two indicated active bleeding. Your Honor, we heard from Dr. Susan Heineck. She testified that she saw no active bleeding coming from the child. She testified that she was able to stabilize the child in a matter of hours for transport to Lubbock. Your Honor, we heard from Dr. Kumar Dharamendra, who indicated the child was stabilized before transport to his facility at Covenant in Lubbock. Your Honor, he testified the baby did not present a septic. Your Honor, he testified that there was no active bleeding. He testified that the child was stabilized. Your Honor, Dr. Drennan testified when she examined the child's vital signs were normal. Dr. Bowman testified the first time he evaluated the child, his vitals were good. He was alert. He was active. Your Honor, he further testified that stabilization was quick and in fact less than 24 hours. Returning to the definition of great bodily harm, we clearly do not have permanent or protracted loss, loss that would have extended over a period of time. We essentially have that the child was hospitalized for a matter of a few days. And the doctor testified that he was stabilized within 24 hours and they kept the child for additional monitoring. Your Honor, we essentially have no evidence of serious disfigurement as required by that statute for great bodily harm. Your Honor, the state is clearly making a case that the child obtained an injury that creates a high probability of death. However, Your Honor, that argument is flawed. All of the testimony elicited indicates if exposure had continued, it would have resulted in death. It would have most likely resulted in death. However, Your Honor, they have the burden of proving that the actual injury obtained created a high probability of death. That simply was not shown. All of the testimony indicated that the child recovered quickly. Therefore, defense would move for directed verdict, and we would ask that it be granted as it relates to abuse of a child resulting in great bodily harm. Thank you, Your Honor.
Stay.
Your Honor, the state would ask the court to obviously deny the motion. We believe that the defense is misarguing the law applied to the facts. Child abuse, great bodily harm as endangering the life or health by a situation or exposed to inclement weather as the state is proceeding on the charging document and in the proposed jury instructions caused great bodily harm. Dr. Nino testified that this child being wrapped in a wet blanket in a trash bag in the freezing weather for approximately 6 hours without any fluids or any nourishment at any time would have led to the inevitable death. The fact that there was intervention, they got fluids started, there was a blood transfusion in order to bring up the heart rate of this child. They continued to warm the child with warm IV, a heating lamp, warm blankets, and they tried to warm even the oxygen at the ER to warm this child. The child had bradycardia, profound hypothermia, blood loss, anemia, kidney failure, and liver enzyme issues. This child's injuries were testified to by many doctors, and it was to only their treatment and the individuals that found this child and immediately took action that it did in fact survive. We'd ask for the court to deny that motion.
Viewing the evidence in the light most favorable to the state, there is sufficient evidence that a jury could find beyond a reasonable doubt that the defendant committed the crime of abuse of a child resulting in great bodily harm. There was substantial medical evidence that the child was subjected to an unjustifiable risk of serious harm, but for medical intervention, he suffered a strong possibility of injury to his vital organs, and the cold that he was exposed to in and of itself put him in such a crisis situation that his heart rate was very low, that the consequences clearly indicated that it could result in damage to organs, in particular his kidneys. The motion is denied. Okay, I see we have Dr. Cave here. Have you had a chance to address Dr. Cave with
The restrictions?
the restrictions?
Yes, sir, I did.
All right, thank you. And that was done, as you know, because of the very late disclosure of a report that the defense had for votes.
Yes, sir.
Once again, Ms. Avila, it's my obligation to advise you whether you testify or not. You should discuss with your lawyers, but in the end, it's your personal decision. Are you prepared at this time to identify whether you plan to testify or not?
Your Honor, not at this time. We were communicating this morning and we will need further consultation.
That's
before the
fine.
decision is made.
That's fine. Okay, anything that needs to be discussed out of the presence of the jury from the state?
No, Your
from the defendant?
Nothing from the next.
Okay, the jury will be back here at 1 o'clock. Let's be ready to go. I'll be looking at your jury instructions over lunch, and I know that they're going to be modified slightly to take out the designation of the baby as baby boy, Avila as baby boy. Okay. All right, court's in recess. Please be back at about 10 minutes until 1.
Your Honor, the state did send an email statements out to the state. The state did request that that's not released in front of the subpoena, even if he is not called for defense case, for purposes of potential states to move on.
Judge.
Okay, well, let's go on record. Let's go on record. State of New Mexico versus Alexis Avila, CR 2022-13. We are in open court out of the presence of the jury. Before we went on record, Mr. Probosco indicated that the state wished to have Stephen Astorga held pursuant to the subpoena in the event they wanted to use him for rebuttal. Ms. Otopoji.
Yes, Your Honor, I have not seen my email since lunch. We did decide to not call Stephen Astorga. He went to lunch. I had our investigator inform him that we wouldn't call him. I can reach out to them and let them know that the state still wants them as witnesses, but last I heard they were out at lunch.
Okay, and what you had told Mr. Astorga was you weren't going to call him?
I told him before the interview that I may or may not call him, but I did not talk to him after the interview. I let our investigator tell him that I would not be calling him.
Okay. But he is subpoenaed?
I did subpoena him, yes.
Okay. All right. Okay, are we ready to go on, bring the jury in?
No other issues from the state.
Defense?
No, Your Honor.
Please stand for the jury. You may be seated. Thank you. The defense may proceed. Do you have a witness?
So Judge, it's going to be Susan Cave, and just want to make sure she's right outside.
All right. All right.
And I should have said something.
I'll go get it.
Thank you. If you'd come forward, Dr. Kidd.
Thanks.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of law?
Yes.
You may be seated. Thank you, ma'am.
Hi, Dr. Dave.
Good afternoon.
Yes, ma'am. Do me a favor, just state your name for the record and spell your last name.
My name is Susan, middle initial B, last name Cave, C-A-V as in Victor, E, Ph.D.
Hence the doctor, right?
Yes.
So let's just start with your background. So, what the PhD? What type of doctor are you exactly?
I have a doctorate in clinical psychology that I earned from the University of New Mexico, Department of Psychology, in 1979.
Good deal. So let's talk a little bit more about your qualifications as you say, one more time, forensic psychologist?
I'm a clinical and forensic psychologist.
Okay, so you're both. So what all did you have to do to obtain those, that status?
I grew up in Southern California. I got a bachelor's degree from California State University at Los Angeles that I earned in 1970, where I graduated with high honors. I applied to the University of New Mexico and moved out here to Albuquerque back in the fall of 1970 and began graduate school. So I was a continuous graduate student from 1970 to 1979. Along the way, I also earned a master's degree in psychology from that same department. And as part of my training, I completed a one-year internship that I did at the University of Oklahoma Health Sciences Center in Oklahoma City. So I was there for a year where my internship was with the Veterans Administration Hospital. And both the internship and the doctoral program are approved for the training of clinical psychologists by the American Psychological Association.
Okay, so, and you mentioned that ultimately you were a PhD, unless you just said that and I missed it. You were in a PhD and that was in psychology?
In clinical psychology.
Clinical psychology, okay. And then you're also a forensic psychologist. What specifically did you have to do to get that? I mean, I know you just told us all that you did, but what specifically makes you forensic and clinical, or forensic versus clinical?
Because I practice clinical psychology in the world of forensics, which is related to courts.
Okay, okay. So how, I know I should be able to do the math. How long have you been a practicing psychologist?
Well, I've been licensed since December of 1981.
And you've been doing it since then continuously?
Continuously since then.
Okay. And what let me get over my thoughts. How many patients have you seen in that amount of time?
Well, I figure in those 40 years that I have evaluated or supervised the evaluations of approximately 10,000 people. Basically, I'm a government contractor. I do psychological evaluations for government agencies, including the courts in New Mexico, including Children, Youth, and Families Department, including police departments, so I do a lot of police psychology. If you're going to be a police officer in New Mexico, you have to pass a psychological examination. So I do that for state police, 7 Native American pueblos, and nearly all the departments in northern New Mexico, north of I-40. I also do Cibola County, City of Grants, and the village of Milan.
And that your involvement in this case was because you were retained to do an evaluation of Alexis Avila, right?
Yes.
How many times have you testified in, let's just talk about criminal court, district court?
Since 2012, I've testified over 400 times.
Have you been qualified as an expert by those courts?
Yes.
Ever not been qualified?
No.
What other are you like we talked about? I've heard about board certification. Do you have anything like that?
I am certified by the Board of Psychology Examiners for the independent practice of psychology in New Mexico. And I've had that licensure since, again, December 1981. Just like your hairdresser, your barber, your contractor, your plumber, your electrician, we are all licensed by the state.
And then this practice is ongoing, so what do you do to, is there anything you have to do to maintain your licensure, like on a yearly, or whatever it is, tell the truth?
Right, you're required by the licensing board to get 60 hours of what they call continuing education every 2 years. So we submit it every 2 years when we renew our license.
But Judge, at this time, I would like to recognize by the court as an expert.
Any objection?
Objection to what are we qualifying her as an expert in?
The court's going to recognize her as an expert in the field of clinical and forensic psychology.
I'm going to object to the forensic portion, Your Honor, if you may approach.
You may approach. The court recognizes Dr. K, who is an expert in the fields of clinical and forensic psychology, and she may give opinions in that area.
So Dr. K, I've already alluded to how you got involved in this case. You did, in fact, evaluate Alexis Avila, right?
Yes.
When about was that?
I saw Alexis on May 23rd, 2022.
You know, before you do an evaluation like you did, what do you do? Do you receive any information about the case?
Yes.
What do you receive?
Well, we usually ask for the police reports, so we know, what the police record is of what transpired, what they're being accused of. So we get that. So I look that over. I may chat with the defense attorney, find out what it is, why they think they need a psychological evaluation, and then we schedule it.
Okay. And do you receive the actual court order for evaluation? Is that part of your preparation in doing an evaluation?
Yes, if there's a court order.
Okay. And do you not receive information from the defense attorney in terms of written information, background information?
I might.
Okay. But in this case, you did get police reports. You do know about what she's charged with and the details behind those allegations?
Yes.
Okay. And you sat in the courtroom for a portion of the trial, and I know it wasn't very much. But you were sitting back here observing about an hour ago, 2 hours ago, right?
Yes.
And didn't you also have a chance to watch her interview with police?
Yes, I did.
So, in preparing for that evaluation, I'm assuming you do an interview with other people beside her? Yes or no?
Yes, but I usually don't talk to other people till after I've seen the defendant. I want to have my own contact with them and have my own impressions and have my own opinion of kind of what their functioning is. And then I talk to other people like family members, spouses, siblings, parents. We call that a collateral contact.
Okay. Did you do any of that in this particular, in this case?
Yes, I talked to her mother.
Did you ever talk to her father?
No.
Okay. And so, when you interview her, you get background information first, is that right?
Yes.
Okay, and what is it, does that just consist of, like, when we talk about background information, is it just everyday stuff?
No, we're talking about, well, the first thing we have to do is explain why are we here and who has access to this information.
Okay.
Because it's not a normal doctor-patient relationship that is protected by regulations, that is private medical information. So we're doing an evaluation for a third party. So we have what's called an informed consent, explaining that this is not confidential because I'm going to share this information with, in this case, the defense attorney. If it's upon order of the court, I'm going to share it with the judge, and he decides where it goes from there. So you need to clarify that first. And then when we take background information, it's a personal history. Where you're born, your parents' names, siblings, where you live, where did you go to school, what grade are you in, how are you doing in school. If it's she's only 18, so just some work history, but not much. Or we want a work history, married, divorced, children, and so on. But she's not old enough to have any of that happen. So that's what we call background information.
And you obviously did that in this case. You did have a conversation with her about all that, sort of those topics that you just mentioned, right?
Yes.
School, work, friends.
Right. Alcohol and drugs. Yes.
Okay. Her relationship with her parents, her siblings. You get into that stuff.
Yes.
And about how long did you talk to mom?
I think to talk to mom,
Yeah, how long did you speak with her mother?
her mother, I probably talked to her mother maybe half an hour.
And is that sort of like a background aspect of the evaluation or no?
Yeah, and I want to see what the parent has to say about the child. What are the issues they've had with her in the home? Or what kind of issues does she see in the school or with her friends, and so on.
Okay. Now you also do, you do collateral information. Well, you just kind of mentioned that. Again, this is sort of, collateral information is, help me with that. What is?
Well, collateral could be educational records, could be medical records, could be talking to family members, so that's all considered collateral contacts. If there's been any prior psychological evaluation, any educational evaluations, and so on.
In this case, was it just primarily speaking with Alexis and her mother?
In this case, yes.
And then, of course, during this, you're sort of observing. You're observing her demeanor. Is that the best way to put it?
Right. Well, yeah, I'm observing her demeanor, how she acts, how she speaks, her mannerisms, the vocabulary, the sentence structure, and so on. So I'm observing her behavior.
Right. So, in other words, it's not just interviewing her and taking this information in. You're assessing her, not just based on what she says. Is that
Right.
a way of putting it?
Right, it's based on what I can observe.
Right. And then you do actual psychological testing.
Yes, I do.
Do you recall, if you recall, what specific testing you did?
I gave her, first thing we give is a test of what's called effort. We want to know if a person is doing the best that they can do. So we have psychological tests that look at that. Is this person trying? Or are they trying to fake us out? Trying to fake bad, or are they trying to fake good? Because it could go either way. So yeah, we have tests that do that. And they're usually real easy. So if somebody wants to fake bad, they'll goof up on the easy stuff so that it's obvious that they're not trying very hard.
What would you take away from that?
We gave her a test called the rate 15 with recognition phase. So we gave her that, and it's real easy. It's capital A, B, C, the numbers 1, 2, 3, circle, triangle, square, 1 hash mark, 2 hash marks, 3 hash marks, and then lowercase a, B, C. So we give her that. We let her look at that for 10, 15 seconds till she thinks she's memorized it. We tell them, you gotta memorize it. Then we pick that up, we give them a blank piece of paper and say, copy down as much as you can remember. So because they're all linked within a single line, they should be able to remember it. So a person with average memory should be able to remember 9. If it's less than 9, they're either trying to fake us out or they may be hallucinating or grossly out of touch with reality. And then after they do draw it from memory, then we give them a piece of paper that has 30 items, which is twice as many as the original 15. And the original 15 are embedded in those 30 items, and we have them put a circle around all the ones that they'd seen before. And so then you add those two numbers together, and most people should be able to get 20 out of the 30.
So that was to determine, essentially that's to determine, like, sometimes they use the phrase malingering or?
Right.
Which means faking it, or?
Malingering is faking it.
Okay.
Like going to the doctor and claiming you have back pain because really what you want is a prescription for narcotics. That's malingering.
Based on that test, just that test, were you under the impression she was exaggerating, faking, malingering, anything?
She got 24 out of 30, so that means she was putting forth good effort.
And then, can you talk to me about other, I know you did 1, 2, 3, 4 that are of relevance to our conversation today. What was the next one?
Well, I was a little concerned about her use of language and how she spoke. It seemed to me that cognitively, her ability to think and be logical and rational.
Objection, Judge, if I may approach.
Well, she hasn't even, all right, come forward.
Everyone's good.
Objection overruled, you may proceed.
So,
Okay, so I was concerned about her speech and her use of language, and her thinking seemed very, what I would call concrete, very literal. So she didn't seem to present with what we call the ability for abstract thinking, which is a higher order of thinking. An example is the difference between a dog and a lion. What's the difference? Well, there's a lot of things in common. They have 4 feet, they have tails, they're covered with hair, they're carnivores. But the abstract answer is that they're both animals and they're both carnivores. That's the abstract angle. That's the higher order answer that kind of covers all the rest. The rest of that is what we call concrete, literal thinking. I mean, it's all true, but the higher level is to say they're carnivores and they're animals or they're predators. That's the higher order thinking. So her thinking was very concrete and literal. So because of that, I gave her a test that looks at how her brain works. And the name of that test is the Cognitive Linguistic Quick Test Plus. So we call it the CLQT Plus. It has 11 subtests, and it measures brain functioning across 5 areas: attention, memory, language, what we call executive functioning, which is decision-making, thinking, planning things out, anticipating the consequences of your actions, and one called visuospatial skills, which is the ability to accurately perceive 3-dimensional space, like doing a puzzle or drawing a map. That's 3-dimensional space. So I gave her that test, And I found something that's very interesting, and I think it's key to understanding what happened here. And that is that she is moderately impaired for attention. Almost like a child with attention deficit disorder.
Dr. K,
Yes.
you need to answer the question that's asked. And I think you've already answered it. You may ask your next
Okay.
question.
So, you did a personality assessment screener. What is that for?
That's a very quick, it's 22 questions, it's 1 page. It's a quick assessment of what's going on in the personality. Is she anxious, depressed, suicidal, psychotic, and so on. So that's what that is.
And you did do it.
Yes.
And then a trauma symptom, well, let me ask you this. Ultimately, you were able to diagnose somebody with, I believe you diagnosed with bipolar disorder. Could you speak to that?
Yes. Bipolar disorder is what we call a mood disorder, where a person has highs, and they can be angry, irritable, full of energy, not needing to sleep, but they can't focus, they can't concentrate, they're tearing around, they start 100 projects in one day and can't stick with anything. That's the high, that's what we call mania. And then there's the low, where they get really depressed, lethargic, have no energy, lose interest in things that used to be important. So she manifests these kind of big mood swings like this.
Now, more specifically, because I know I just said it, you diagnosed with bipolar 1 disorder.
Yes.
Cyclical.
Yes.
And explain to the jury, what cyclical is that what you just described, the up and down?
Yes, cyclical is the up and down. I mean, we all go up and down, but these people have huge swings, and they can turn on a dime.
Okay. Now, you obviously did this after she was charged and accused of this crime. You did this assessment after that occurred, right?
Yes.
Is it your opinion that she was bipolar, is, and will be, or do you know what I'm saying? I want it to be clear for the jury that this is something that you can say, hey, she was this even prior to the criminal activity that she engaged in.
Objection to the form of the questions, Leanie.
Okay, well, so,
If you'll refresh.
yes, we've already established you diagnosed with bipolar disorder.
Yes.
When do you have an opinion on when the onset of that may have been with Miss Alexis Avila?
It can be in childhood or adolescence.
Did you perceive that from your work with her?
Yes.
Okay. So, okay. I mean, I know it's probably hard to put a concrete time frame on it. Could you give an opinion as to when you think the onset of this was for her? Could you do that?
Objection, Judge, this is outside the scope of the court's order.
Overruled.
I think it may have started when she was about 14 or 15. I think it'd been there for a while. And it's lifelong. It doesn't go away. It's like having diabetes. You can manage it, but you can't get rid of it.
Now, if somebody were to become pregnant and be bipolar, cyclical, what kind of effect would that have on a person? Emotionally.
Well, pregnancy comes with a lot of hormonal changes. And so pregnancy can kind of emphasize mood swings. So in a person like her that already has kind of this predisposition or has these early symptoms of it, the hormonal changes associated with pregnancy are going to be amplified because they're going to interact with that underlying condition.
So people with bipolar 1 disorder, what are some of the, if you could tell the jury, what are some of the ramifications of that in a situation like somebody getting pregnant and then being accused of abandoning the child?
Well, again,
Objection, Judge, this is outside the scope of the court's order.
Please approach. Objection overruled, you may proceed.
Well, the hormonal changes of pregnancy are going to amplify and even exacerbate, make the underlying mood disorder stronger and more prominent. And that cannot be controlled by the rational part of the mind.
You mentioned like similarity to ADHD. Would she, I don't know, is that a diagnosis or, I mean, can you help us with that? Is that associated with bipolar disorder?
No, it's independent. The attention deficit disorder is something that you see, it can start in kids, it can adults can have it, and made it all the way through school before they realized it, that they can't focus, they can't pay attention, they can't concentrate for very long, even if it's something that they care about and is important to them, like some project they're working on or some hobby that they're working on. And so they lose focus, they lose concentration. So they're not paying very good attention to what's going on in the world around them. And so they may just gloss it over or ignore that.
We talked already about you interviewing her, and you're aware of the allegations surrounding this case, right?
Yes.
When you interviewed her regarding the incident, was denial a factor in what was going on with her? Was that your perception?
Objection to leading.
Sustained. You can ask her what factors she relied on, but you cannot lead.
So, when you interviewed her, was she aware, based on your interview, that she was pregnant prior to, this event occurring?
She told me the same thing she told the police, which was that she found out about it the day before on January 6th, when this incident happened on the 7th.
Was there another fact regarding menstrual cycle that was interesting to you?
She said that, so I asked her about that, basically trying to answer the question in my own mind, how do you know you're not pregnant? When it obviously makes major changes in your body. And she basically said she had her period every month through the pregnancy, which I think is physiologically and physically impossible.
So what would you characterize that as? What mentally, psychologically, what is she doing?
Well, that's the defense mechanism of denial. And denial is a very powerful defense mechanism. It's like the alcoholic saying, oh, I could quit drinking any time, I just don't want to. There's no reason for me to. Or the smoker, I can quit smoking at any time, I just don't want to. That's denial, that you don't have a problem when everyone around you thinks you do.
In speaking with her mother, was the mother aware of what was going on in this child's life?
Objection, hearsay.
Sustained.
Sorry. Is there any other traits of bipolar disorder in this particular individual, Miss Avila, that a characteristic that she exhibited based on your evaluation and your knowledge of the case?
Objection to the form of the question and speculation.
Overruled.
Well, part of her mechanism of denial that something isn't happening is what we call dissociation. Dissociation is kind of hard to explain, but it's how all our minds can wander. We can think about something in fantasy. You can drive down the road 20 minutes from here to Hobbs, and your mind can be off thinking about something else. and you're not really paying attention to the road, but some part of you is because you didn't wreck your car. And so that's dissociation. We take our mind and we put it somewhere else. And some of that may be automatic, so it's not necessarily a choice. Our mind can just drift off like that. So that's what dissociation is, where a person detaches from what they're feeling and is thinking about something else.
Having read the police reports and spoken with her and all that we just talked about, is it your opinion that that's what was occurring after the baby was born?
Yes, she called it being in shock, which I think most people can understand.
Animal.
You may.
Thank you, Dr. Cape. I'm gonna pass the witness, Judge.
All right, cross-examine.
Good afternoon, Dr. Cave.
Good afternoon.
I want to start by discussing your background. Just to be clear, you're not a medical doctor.
That's correct.
Okay. And similarly, you're not a prescribing medical doctor.
I'm not a prescribing psychologist.
Okay, so you cannot write prescriptions for medications.
That's right.
So you have no specialization, certification, board licensing regarding prescriptions of medications.
No, I do not.
You conducted your interview of Ms. Avila on May 23rd of 2022, is that right?
Yes.
And it was 3 hours long.
Yes.
And you're aware that the incident that we've been discussing in this case occurred on January 7th of 2022?
Yes.
So you interviewed Ms. Avila, or the defendant, 4 months after the alleged incident that we've been in trial for.
Correct.
Would you agree that someone's mental state could change over the course of 4 months?
Certainly.
You testified on direct that you relied on a number of things to come to your conclusions in the report that you generated.
Yes.
Interviews
Yes.
with the defendant that you conducted.
Yes.
Interview with the defendant's mother.
Yes.
Police reports.
Yes.
And you did not review, prior to creating this report, the interrogation with law enforcement.
No, I did not.
You also did not review any medical records or documentation prior to forming your opinions in this report.
That's correct.
And you agree that this report that you generated was accurate?
Reasonably so. I can't say it's 100% accurate based on what I knew at the time.
Well, would you agree that you gave a thorough evaluation?
I think it was pretty thorough.
But you didn't follow up in terms of any medical records for Ms. Avila?
No, I did not.
Okay. And you didn't speak with any treating physicians?
No, I did not.
Nor did you personally speak with any law enforcement officers involved in this case?
That's correct.
Or any peers or additional family members of the defendant?
No, I'm a psychologist, not an investigator.
Okay. But you did arrive at conclusions in your report?
Yes.
You did agree that based on your testing of the defendant that, based on your interview of the defendant, that she was doing well in school.
Based on the reports I had, yes.
And she was working.
Yes, she had a part-time job.
And you have testified here today that the defendant suffers from bipolar 1 disorder.
Yes,
And in your report, you based that upon medications that she was being prescribed.
that's just one factor in that diagnosis.
So that was one of the factors you relied upon, and if I can direct you to your report, do you need a copy of it?
No, I have it.
Okay, on page 4, the third paragraph, that she was clearly being treated for bipolar 1 disorder, and that was following the list of medications that the defendant reported to you.
Yes,
You never verified those medications.
no,
You never verified that they were actually prescribed.
no.
You also, during your evaluation of the defendant, asked her some inquiries, and I'll direct you to your report on page 5, the first paragraph. Do you see the second sentence beginning with, she was asked to interpret the saying blood is thicker than water?
Yes.
And what was her response to you?
No matter what, you have your family to be there for you.
May I have a moment, Your Honor?
Yes.
My last series of questions, Dr. Cave, is you're being paid for your testimony today, is that correct?
Yes,
How much are you being paid?
$200 an hour.
And who is paying for your fees to testify?
The law office of the public defender.
Nothing further, Your Honor.
Redirect.
I believe so, Judge. On cross-examination, you were asked about the family dynamic, and just now, the last question was, blood is thicker than water, what does that mean? You interviewed mom, you interviewed your daughter. What is your assessment of their relationship?
Objection to hearsay.
Overruled.
It's also beyond the scope, Your Honor.
Overruled.
The mother told me something very interesting, which is,
Just a minute. The question was the assessment of the relationship, not what anyone told you.
okay,
Yeah, without talking about what.
okay, what anybody specifically said, okay. These women are not very good at talking about how they feel. In fact, they both seem to bottle it up and hold it inside. As an exercise, let's see. They even tried to write things out, which is called journaling. You write about how you feel, and they couldn't, neither one of them could do that. So these are women that hold their feelings inside and never talk about them. And she has an underlying mood disorder, which means she is,
Objection outside the scope of cross.
Yes, the answer went beyond the question that was asked. The last part is stricken from record at this point,
Your Honor.
as far as mood disorder.
Bipolar 1 disorder does that play a role in that relationship, in that dynamic?
yes,
Did you find it odd that mom was unaware that her daughter was pregnant?
Objection to leading and speculation.
I'm overruled.
yes,
You were asked on cross-examination about not having seen the interrogation of Ms. Avila about law enforcement. Does that, you've seen it now,
yes.
does it change your diagnosis or anything you've said here today elicited from you by me?
Objection, this is outside the scope of the court's order. If we may approach, Judge.
You may approach. The objection sustained in part.
So, let me just ask it again, Dr. Baker.
Your Honor, maybe the interpreter asked that Mr. Cummings just raise the volume of his voice just a little bit more, Your Honor.
Yes.
Me?
No, me. You know, I mean, that's usually not an issue, but maybe I overcompensate or something. So, Dr. Cave, we talked about the fact that you watched the interrogation today, right?
Yes.
And again, the evaluation you did that we referred to earlier, what was the date of that again?
That was in May of 2022.
May of 2022. Having watched that video, does it change your opinion in terms of what you've testified here to today in relation to that evaluation?
No.
And you were asked about 4 months passing between, I believe, the time of the alleged crime and your evaluation, right?
Yes.
And you agreed that 4 months people can change in 4 months. I think you agreed to something like that when asked. Was that
Yes.
like that time? In this particular case, with this particular individual, your patient, or at one time your patient or evaluee, do you believe that 4 months period between the time of the alleged crime and your evaluation had any impact on the way you perceived Alexis Avila and your opinion of her?
Objection, speculation.
So, I'm sorry, would you repeat the question and don't answer Dr. till I hear it?
Essentially what I'm asking is, she was asked on cross about, hey, 4 months passed and people can change, you agree with that? She didn't ask about this particular individual. People in 4 months can change, their behavior can change. And she said, yeah, that's true. And I just am asking her, in that 4 month period between the alleged crime and her evaluation, does that affect your opinion? Do you think that it has any bearing on your evaluation of her and your testimony? Like it's a yes or no question.
I'll allow her to answer yes or no. Objection overruled.
I don't know if you caught that as I just repeated in front of the judge. I know it's a little verbose, but it's a yes or no question. Essentially,
Does the 4 more month gap in the time that the alleged incidents occurred and when you saw her change your opinion?
No, it doesn't change my opinion.
now, when you were you were asked about how you get paid. When you testify to the courts, for the courts, do you get paid by the courts?
If I do it under court order, I do not get paid for testimony. That's the contract I have with the state.
But if it's under court order, they pay you something, is that all right?
I get paid for doing the evaluation itself.
Okay. Have you ever testified for a DA's office or a prosecutor's office?
Yes.
Okay. Do you get paid by them for that testimony if you're called to testify at a trial?
Yes.
Okay. And is it customary for experts to get paid for their testimony in court?
Yes.
Okay. I think that's all I have for now, Judge.
Any follow-up from the
If I
judge?
may just have a moment, Your Honor.
You may.
Nothing further, Judge.
All right. gentlemen of the jury, you must not conclude from Dr. Kaye's testimony that the defendant was incapable of the deliberate intention to take away the life of another. This expert testimony was admitted solely to assist you in determining, based on all the facts and circumstances of this case, including defendant's mental condition, whether defendant in fact formed a deliberate intention to take away the life of her baby rather than an unconsidered and rash impulse. Any questions from the jury? Any objection to excusing Dr. Kaye?
Not from the state.
No, sir.
You're excused. Thank you. Call your next witness.
Your Honor, the defense has no other witness in, except for Ms. Avila in the event she chooses to testify. So I don't know if the court wants to inquire about that. Should I proceed on that?
At this time, ladies and gentlemen, we'll need to take a break. During the break, don't discuss the case. Don't allow anyone to discuss the case in your presence. Don't do any independent research about the case. Don't form any fixed opinions about the case until the case is finally submitted to you. Please stand for the jury. All right, you may be seated. And for the record, the limiting instruction that I gave was the one that I referenced in my order in this case on April 4, 2023 that would be given, and comes from the case of State versus Valderrama, 2004, New Mexico Supreme Court 8. Ms. Avila, as I have told you previously, you have the right to either testify or not testify. If you don't testify, and the jury will be given an instruction that tells them they're not to consider it in any fashion. You have 3 lawyers that you've had the chance to discuss the matter with. There may be good reasons either for or against testifying, but it's your personal decision. After consulting with your lawyers, have you made that decision? And what's your decision?
I will testify.
You will be testifying?
Yes, sir.
All right. As soon as the jury's done with the break, we'll resume. Court's in recess, I'd say about 10 minutes, 2 o'clock.
All rise for the court.
You may be seated. Without opposing, call your next witness.
The defense will call Alexis Avila to the stand at this time.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of law? You may be seated. You're going to need to speak up, please. Okay, thank you.
Alexis, please state your name for the record.
Alexis
What's your last name?
Avila.
How old are you?
I'm 19 years old.
How old were you in January of 2022?
I'm 18 years old.
And when is your birthday?
December 22nd.
Okay. In January of 2022, we've learned that you were in school at that time.
Yes.
What grade were you in?
I was a senior.
Okay. Were you involved in any school activities?
Not my junior and senior year, no.
What about prior to that?
Yes. In middle school, I was in band, and my 8th grade, freshman, and sophomore year of high school, I played softball.
Okay. Why did you stop playing softball?
I was in a car accident, and I wasn't cleared to play until the end of junior season.
Okay. Around when was the end of junior season?
I'd say May, maybe.
May of, April, May of what?
2021.
2021. Okay. Was softball being played at school at that time?
Yes.
Okay. Had the pandemic affected sports at school?
Yes.
So did you return to playing softball after you got cleared?
No.
Why did you not return to softball?
I chose to work instead.
So you had a job?
Yes.
What kind of work did you do?
I was a sales associate at a clothing company in Hobbs.
Okay. Where did you live around this time?
In Hobbs.
With whom?
My parents.
So both your mom and your dad?
Yes.
Okay. You have any siblings that live with you?
No.
Do you have siblings?
Yes, ma'am.
How many of them do you have?
2.
Okay. Brothers, sisters?
Well, one of each. I have one brother and one sister.
Do they have children?
Yes.
How many children do they have?
My brother has 4, and my sister has 2 and 1 on the way.
Okay. Prior to January of 2022, did you spend time with your family?
Oh, yes.
Okay. Now we're gonna go and talk about January specifically, okay?
Okay.
And we're gonna start from around the 4th of January.
Okay.
We have learned in court that you did have a hospital visit
Yes.
on January 4th.
On Tuesday, I believe? Yes. Yeah.
It was a Tuesday.
Yes, ma'am.
Okay. Why did you go to the hospital on Tuesday, January 4th?
I was having back pain.
Could you describe what that was like?
Kind of like a sharp pain to my muscles, kind of like a sharp twist to my muscles and bones.
What part of your back?
My lower back, lower hip.
Okay. So, is this pain that you were familiar with, or was it unusual?
No, I'm very familiar with it.
Why?
It happens frequently, multiple times out of the week. It's nothing out of the ordinary.
Okay. Do you know what the cause is?
The accident, when I got in the accident, I got a referral to Odessa, and I got x-rays done, MRIs, and the doctor said that I had a crack in my bones on my L4 and my L5, and there was fluid in there.
Okay. And was your doctor a pediatrician?
Yes.
Okay. So when you went to the hospital on January 4th, it was no big surprise, was it?
No, ma'am.
Okay. What did you tell the professionals at the hospital?
The same that I just told you. I had lower back pain and that I got in a car accident.
Okay. And what did they do?
They didn't do much when they did see me. I believe only one doctor touched me, and the other, he just leaned over the counter and just spoke to me.
Okay. What else did they do?
That was about it. They just told me what not to do and what to do.
What did they tell you not to do?
The doctor that released me, he said that I had some kind of strain. I did at the time work with heavy boxes, lifting them, bringing them down, putting them up, vice versa.
Okay. Now, about your work, so this is Tuesday, January 4th we're talking about, right?
Yes, ma'am.
When was the last day you'd gone to work before that date?
I believe Monday, I'm not sure.
Okay. So Monday was January 3rd, correct?
Yes, ma'am.
Okay. So on January 4th, did you get any prescriptions at that time?
Yes, ma'am.
And what happened?
They just sent me home and told me to take it when needed.
Was that for the pain or was it for something else?
It was for the pain.
Okay. So did you take it?
Yes, ma'am.
What effect did it have on you?
Not much. Not a lot of medication helps my back pain. So it helped for maybe 10 minutes, if that, and the rest it didn't.
Okay. Were you able to work on January 4th?
No.
So you did not go to work on that day?
No, ma'am.
Okay. Let's fast forward to your January 6th hospital visit. Now, before we get to January 6th, so you were a senior in high school, you say, right?
Yes, ma'am.
Okay. What else was going on in your life around that time?
Nothing that I could recall. Just getting ready for graduation from senior stuff.
Okay. What about college?
Oh, yes, and college as well.
What were you doing to get ready for college?
Touring them, applying to them.
Okay. What college were you most interested in?
Your Honor,
McMurray
just
University.
an objection to any course of inquiry that's not relevant, so that is the objection to relevance.
I'm going to overrule it, it's background information. May proceed.
Thank you. What college were you most interested in?
McMurray University.
Okay. And what were you going to study?
Most likely some sort of psychology, some sort of teaching. I wasn't quite sure.
Okay. So then, January 6th, you had to go back to the hospital. Why did you go back on January 6th?
For the pain. Whenever I went to the hospital in Hobbs, the doctor that seen me, the last one to see me, the one that released me, he said that if I had any further pain to go to my primary doctor.
Okay, and that was the doctor who saw you on January 4th, correct?
Yes.
Okay. Just to clarify something, did you go on January 4th by yourself?
No, ma'am. I went with my mother.
Okay. So that doctor tells you if you have further pain, see your primary care doctor?
Yes.
And would that be a pediatrician?
At that day, no. She was not available.
Okay. So on January 6th, you go to see another doctor. Okay. You have to say yes.
Yes. Sorry.
All right. So January 6th, you go to see another doctor. What happened at that visit?
I explained to them my pain as well, and they told me to pee in a cup.
Okay. And did you do that?
Yes, ma'am.
Okay. And then what happened?
And then shortly after, one of the doctors comes, or the doctor that I did see, she came into the room and told me I was pregnant.
How did she deliver that news to you?
When she came in, she kind of put her hand on my knee or on my leg, which I don't really like people touching me, so I was uncomfortable with. And then she told me that I was pregnant.
When she told you you were pregnant, what did you think at the time?
I'm not sure. I kind of blacked out.
Why did you black out?
I was in shock, I guess.
What else did she tell you?
Oh, I don't remember.
Why don't you remember?
Because I blacked out.
How long were you there for, do you know?
No, ma'am.
What did you do next?
I think I went to work. I was scheduled to work on the 6th.
Before you went to work, before you left the doctor, did they give you any information as to what to do next, anything like that?
No, ma'am. They just told me to stop taking the medication that the hospital provided me with.
Okay, so you remember that part?
Yes.
Okay, is there anything else that you were told that you remember?
No, ma'am.
Okay. Did you understand why you had to stop taking that medication?
Not fully, but yeah, not fully.
Do you now realize why you were told to stop?
Yes, ma'am.
Okay. So they tell you understand that you had to stop taking the medication and then you left.
Yes, ma'am.
You went to work?
Yes, ma'am.
Okay. What did you do that day at work for the rest of the day?
I wouldn't be able to tell you.
Why not?
I don't remember.
But you remember being at work?
Yes.
Okay. Earlier you told us that part of your work duties involved moving boxes. Was that day any different?
I don't remember.
Okay. Do you know what time you left work that day?
Somewhere around 7:15, 7:30.
Is that your regular time that you leave work?
Yes, ma'am.
Okay. So then you leave work and then you went where? Where did you go after work?
Either to my brother's house or to my house.
Okay. Why would you have, okay, you're unsure as to which one it was.
Yes, ma'am.
Okay. Is there a reason you think you would have gone to your brother's house?
I think they made some kind of food.
Okay. So, was it a family gathering?
Just the normal weekday gathering.
So, is it normal that your family gathers like that at your brother's house?
Oh, yes.
Okay, what about at your home?
Yes.
How frequently do y'all gather as a family?
Before, a couple of times a week, if every other day.
Okay. So then, that day you went to your brother's house probably?
I believe so.
Okay, and then at some point you went back home?
Yes, ma'am.
Okay. Now, we're gonna talk about January the 7th, okay? Something happened that day that brought us to this case today, right? So we'll talk about that day. Before we talk about that though, so when you gathered with your family on the 6th, did you tell anybody what the doctor told you?
No, ma'am.
Why didn't you tell them?
I was still trying to process it myself.
What did that look like for you, processing it?
I wouldn't be able to tell you.
Were you at that moment aware that you were gonna birth a baby the next day?
No, absolutely not.
So the next day, January 7th, what did you do that morning?
Nothing much. I believe that whole day I was in bed
Why were you in bed?
for my back pain.
What did that feel like as at the 7th?
The same, like pulling muscles in my back, like sharp pain.
What about your parents on the 7th? What were they doing that morning?
They were at work.
Both your mom and dad went to work?
Yes, ma'am.
Okay. So you're at home, was there anybody else?
No, ma'am.
So while you're at home, what do you do? other than laying in bed?
That's about it. A couple of times I would get up to use the restroom, or try to, but I would just go back to bed.
Okay, when you say you would get up to try to use the restroom, what was going on with you at that time?
I just felt like I really needed to go to the restroom. I felt really constipated, which is nothing unusual.
So you felt constipation before?
Yes.
So you know what that felt like? And you believe that's what was going on?
Yes, ma'am.
Did you do anything to resolve what felt like constipation?
Not during the morning. There was a time, I wouldn't be able to tell you the time, where my dad did take me some kind of pill. I don't know what it was. It was some kind of constipation pill. And I took that and I went right back to sleep.
Okay. So you go right back to sleep, and then what's the next thing that happened?
I woke up and I used the restroom. Well, my dad was actually there when I woke up after taking the pill. He was only there for a short amount of time. He did probably his insulin or something, used the restroom and left. And then when he when he got out the restroom to leave, that's when I went into the restroom.
Okay. So this time around when you went to the restroom, what happened?
I delivered a baby.
How did that happen?
I don't remember. I just remember sitting there. And then the baby was on the toilet or on the floor. I don't remember.
You don't remember if he was in the toilet bowl or on the floor? So what were you thinking in that moment?
I was in shock. Like, how could this happen?
So what did you do?
I don't remember.
What was the next thing that you remember?
I think when me and my mom left the police station to go to the hospital.
Prior to the police station and going to the hospital, you don't remember anything that happened in that space?
No, ma'am.
You told us that the day before you blacked out when the doctor told you that you were pregnant.
Yes, ma'am.
Is that something that had happened to you before?
Yes.
How often has this happened to you?
Not very often. Not very often where I completely black out.
So on the 7th, how would you describe what happened the moment that you saw the baby that you delivered?
I'm sorry.
How would you describe what happened in the moment that you saw the baby you delivered? You said you were in shock and then you say you don't remember. Would that be, you think you blacked out at that time as well?
Yes, ma'am.
So we're gonna come back to that moment, okay? But for now, let's talk about you at the police station, at the police department. You said the next time that you remember was leaving the police department with your mom?
Yes, ma'am.
Okay. What happened at that time?
When I was with my mom.
Yes.
We were on the way to the hospital to go get me checked out and stuff. And she was just kind of trying to get me to understand what happened.
How was she doing that?
Kind of just like asking me the same questions over and over.
What was she asking you?
She asked, like, why didn't you tell me, or do you know what's going on, or just, do you know how we got here?
And what did you respond?
Your Honor, just objection is to hearsay, the defendant's not a party opponent, this is sort of classic
Sustained. Sustained as to what the mother said.
Okay. We're not gonna say specifically what your mom said, okay? What were you thinking in that conversation with your mom?
Kind of like, no, that's not something I would do. That's not who I am.
So you and your mom were driving to the hospital. Did you make it to the hospital?
No, we did, but we ended up turning around and we didn't go in.
Okay. So we're gonna talk a little bit about your memory of that event, okay? Your recollection of what happened. So you're saying that you do not remember that space of time?
Yes.
You've been in court here with everybody for the last few days, correct?
Yes, ma'am.
Okay, and you've seen videos played. And what have you learned in that time or prior to as we're preparing for court?
That when I delivered the baby, I put him in a towel. I wrapped him up in a towel.
And then, what else?
And then I put him in the car and I drove away. I drove away from my house.
And where did you go?
To the dumpster.
What did you do?
And then I tossed the baby into the dumpster.
At what point did you come to the realization of what happened?
Not for a while, when I was fully able to comprehend and how you and I are speaking, for a couple of months.
What happened to make you be able to comprehend and talk about it?
I've been in therapy.
You're still in therapy at the moment?
Yes.
Now, that night, you did also talk to Detective Perez about what happened. Do you remember having that conversation?
No, ma'am.
Okay. Now, but you did see the video of that conversation.
Yes.
What was your observation of that video? What was going on there?
Like, how was I, or?
How were you? Yes.
I don't think that was me. Looking at that video and how I normally am, that wasn't me. Like, I was looking at a ghost.
And the actions that you talked about during that video, how were you able to tell that story in that manner at the time?
I'm sorry?
How were you able to talk to Detective Perez about what happened?
I don't know. I think he was kind of, when he was asking me the questions, he was giving me the answer.
So part of what happened was, the entire story of you having the baby, wrapping the baby up, you put the baby in a trash bag. What were you trying to accomplish? Detective Perez asked you, what did you think was going to happen? And you did not give him an answer at the time? What did you think was going to happen?
I don't know.
Is there anything that you think now after hearing testimony and seeing more about the case?
Can you say that again, please? Sorry.
Is there anything that you think now could possibly have happened after seeing the case and listening to testimony so far?
And listening to the testimony, yes.
What do you think about that?
About listening to the testimony?
Yes.
It hurts.
What hurts?
The words that they said about what was going on with the baby.
What part of it was most concerning to you?
I guess that he was, I mean, other than like the medical stuff, I guess that he was just left alone.
Do you understand how your actions affected the baby?
Yes.
And what do you think of that?
And that hurts. That's something that he's never gonna forget. That's something that's gonna live with him for the rest of his life, as well as myself.
You did tell Detective Paris that you asked if the baby was okay.
Yes.
Why'd you ask him that?
Because with or without that incident, he's still mine.
What would you have done differently that day?
Absolutely everything.
Like what?
I guess whatever the
Just
doctor.
the objection would be speculation.
Sustained.
If I may have just a moment, Your Honor.
You may.
Alexis, let me talk to you briefly back to your medication, okay? Are you taking medication for any specific mental health conditions?
Defining mental health.
Anything
Is
that,
objection relevance?
Your Honor, this goes to partly the credibility of the witness. The video indicated that she did give.
And Your Honor, can we approach?
You may.
Sure.
Objection sustained.
Okay. I have no other questions. Go to witness, contest the witness at this time.
Cross-examine.
Yes, Your Honor. Ms. Avila, isn't it true that this trial is not the first time that you've heard witnesses testify about what happened on January 7th of 2022?
This trial?
Correct.
No.
So is it your testimony that you did not have a preliminary hearing in February of 2022?
No, I didn't.
And during that preliminary hearing, you do have a recollection of that hearing happening, don't you?
No, ma'am. No, sir, sorry.
And you, so is it your testimony that you have no recollection of the witnesses that provided information about what you did on January 7th?
Correct.
And so you have no recollection of the prior testimony of Detective Perez
Of today or of February?
in February of 2022?
Correct.
And you're claiming before this jury that you have no recollection about the testimony of April Nuttall on February of 2022.
That's correct.
And you're claiming that you have no recollection of the testimony of Michael Green in February of 2022.
That's correct.
And you're claiming that you have no recollection of the testimony of Hector Josso.
Overruled. It's relevant.
And it's your testimony that you have no recollection of the testimony of Hector Josso in February of 2022.
That's correct.
Now, I'm not a mathematician, but February 28th of 2022, that's over a month past when you threw your newborn baby into the dumpster, isn't it?
Yes, sir.
And you would be able to agree with me that you've been able to see video of you committing this crime in this case, haven't you?
Yes.
You can confirm that the video that this jury saw is of you throwing your own newborn into a dumpster.
Yes.
You can confirm that the bag that you used to throw your newborn into the dumpster is contained in this evidence bag, can't you?
I'm sorry, what's the question?
The contents of this bag were used by you, as seen in the video, to throw your newborn into the dumpster. Isn't that true?
If that's the bag that was in the video, yes.
And that's because that was you committing this crime, wasn't it?
Yes.
And with regards to the baby newborn that was inside that trash bag, I'm showing the witness Exhibit 6. It was this baby, wasn't it?
Yes, sir.
He was your baby, wasn't he?
Yes, sir.
And you put him in a trash bag, didn't you?
What was shown today, yes.
I'm showing the witness what's been entered into evidence is Exhibit 18, this trash bag. Do you need me to step closer, ma'am, so that you can see Exhibit 18
No, I can
clearly?
see, I was just waiting for the question.
My question is, it was this trash bag, wasn't it?
If that's the one that's in the bag, then yes, I don't recall the bag.
Filled with all of these bits of garbage, wasn't it?
I don't recall what was in it.
Well, you have eyes, don't you?
Yes,
You can see the picture, can't you?
yes,
Can you see the garbage inside of the bag?
yes,
The bag that you put your newborn inside of on January 7th?
yes.
Let's talk a little bit about this blackout. You claimed on direct examination that you blacked out. That's your word, right?
Yes.
Blacked out. Is that a term of art to you? A blackout?
A term of art?
Yes.
I don't understand the term of art.
Does blackout mean anything other than what an ordinary person would perceive it to mean as you're using it?
I'm not understanding.
What does the term blackout mean to you?
Where I'm not in my body, where I'm there, but I'm not there.
And you claimed on direct that it affected your ability to remember what you did on January 7th, don't you?
Yes.
And you claimed that you kind of blacked out, was your testimony, is that right?
Yes.
And you claimed that you first kind of blacked out when you were informed that you were pregnant, didn't you?
Yes.
Now, this isn't the first time you've received information that you were pregnant, is it?
When?
Well, let's walk through a little timeline. You've heard the testimony about your statements. In fact, you've seen the video of your statements to Detective Perez, haven't you?
Yes.
And so you were able to hear for yourself the positive pregnancy test that you got in August of 2021.
Along with the negative.
Well, let's have my question answered first, and then we'll move on to the negative. You affirm that you received a positive pregnancy test in August of 2021, didn't you?
Yes.
And that's
along with
because
the
you
negative.
did receive a positive pregnancy test in 2021, didn't you?
I'm sorry, say that again?
And that's because you did receive a positive pregnancy test in August of 2021, didn't you?
Yes.
Positive pregnancy test, that means that you are pregnant, right?
Yes.
And when you received that information, can you explain to the jury about your blackout at that point in time?
Well, I was a teenager.
That's because you didn't black out, did you?
Of the first one with the positive and negative?
Correct, in August of 2021.
No. Because there was also a negative.
Well, when we're talking about the positive and the negative test, did you take these tests at an exactly simultaneous time?
I don't remember.
That's because you didn't take two different pregnancy tests at the exact same time, did you?
I don't remember.
And get two exact outcomes at the exact same time, did you?
I don't remember.
When it comes to blacking out, you blacked out in reference to what we can all see on the video, is that right?
I'm sorry?
You blacked out the experience that we can all see on the video, is that right?
Yes.
But you didn't black out receiving the exact same information at an earlier time, isn't that right?
Yes.
Now, with reference to August of 2021, that was not the first time that you received information that you were pregnant, was it?
I'm sorry?
That was not the first time that you'd received information that you were pregnant, was it?
It was.
In fact, you spoke with other people about the fact that you were pregnant as early as April of 2021. Is that not true?
No, I don't remember.
So you're denying it?
Yes, because I don't remember.
Okay. We'll take that you don't remember talking about being pregnant of 2021. You've heard the statement that you made on a recorded video. Is that correct, during the course of this trial?
Yes.
It was a recorded statement between you and Detective Perez, wasn't it?
Yes.
And in that recorded statement, you were advised of your rights. Is that right?
From what I seen in the video, yes.
You were advised of your rights not all at once, but one at a time, weren't you?
From what I seen in the video, yes.
And you were able to confirm your waiver of your rights one at a time, weren't you?
From what I seen in the video, yes.
You were able to observe yourself receive a piece of paper from Detective Perez that contained those rights that you were read one at a time, didn't you?
From what I seen in the video, yes.
You were able to see that at some point you were able to get a pen in your hand, didn't you?
From what I seen in the video, yes.
Are you left-handed or right-handed, or have you forgotten? Which hand?
Oh, I'm right-handed.
So you're able to see you take your right hand with a pen, an initial next to each and every one of those rights, weren't you?
From what I seen in the video, yes.
And you were able to hear yourself talk about exactly what happened at the McKenzie house and address on January 7th, weren't you?
From the video, yes.
And you were able to hear your own words, your own description about where the birth happened, is that right?
Yes.
About where you put the baby after he was born, right?
From the video, yes.
About putting him inside a plastic bag, right?
From the video, yes.
In fact, you were even able to describe a loosely fitting hair tie that probably came on while you were manipulating this plastic bag that had your newborn baby inside of it, weren't you?
From the video, yes.
And you were able to hear yourself describe putting this bag with your baby inside of it, inside of your car, weren't you?
From the video, yes.
Now, you didn't get in any car accidents on January 7th, did you?
Not that I know.
And you did drive your vehicle, didn't you?
Yes.
You were behind the steering wheel of your vehicle, weren't you?
Yes.
Is this a key ignition on your vehicle?
Yes.
Where were your keys that day?
Oh, like in the house?
Yeah.
Oh, I don't know.
Where do you usually keep your keys?
It varies. Either behind the door, hanging up, on the counter, on the coffee table, in my room, whichever.
Did you need your keys in order to start your vehicle that day?
Yes.
Did you just happen to have your keys on you after your baby was born?
No.
But you were able to take your keys and start your vehicle, weren't you?
Well, yes.
And that's because you were able to see on the video yourself driving and operating your vehicle, weren't you?
Yes.
Now, in order to get from the Mackenzie address to the mall, this isn't just, a quarter-mile speed trap where you don't have to make any turns, is it?
It's just one turn.
It's
Or
one
two.
turn.
Two.
2 turns. Approximately a mile away, isn't it?
Oh, I wouldn't be able to tell you.
You've heard the testimony that it's several blocks away, though, haven't you?
Yes.
Do you have any reason to disagree that this is a few blocks away?
Yes.
Oh, you do? Okay, so tell us, what's the basis for disagreement that your house is a few blocks away?
Everybody has their different opinion on what a few blocks away is.
Okay, fair enough, fair enough. But it's not right next to your house, is it?
No.
You had to drive on a road in order to get to the dumpster, didn't you?
You have to drive on the road everywhere, so yes.
Of course, of course. And there's other vehicles that drive on the roads, aren't there?
Yes.
Pedestrians walking on sidewalks,
Not where I live, but yes.
pedestrians crossing streets.
Hardly where I live, but yes.
And you didn't hit any pedestrians or run into any cars, did you?
Not that I'm aware of.
And you were actually able to navigate from your house to the dumpster, weren't you?
Yes.
And you were able to take the bag that your newborn child was inside of with no apparent problems, as you can see in the video. Is that right?
Correct.
And you were able to navigate space inside of that dumpster that you were able to throw your newborn baby inside of, weren't you?
No, it's not like I calculated the length of the dumpster, no.
But you didn't miss the big old hole on top of the dumpster, did you?
From what I seen in the video, no.
Oh, you made putting your newborn into the dumpster, you didn't miss, did you?
From what I seen in the video, no.
And that's because you were able to get your newborn inside those bags into the dumpster, weren't you?
I'm sorry?
You were able to get your newborn baby into that dumpster, weren't you?
From what I seen in the video, yes.
And you were able to turn around just before your baby makes impact with the garbage in that dumpster before getting into your vehicle, weren't you?
From what I seen in the video, yes.
And you were able to observe yourself driving away from the dumpster, weren't you?
From what I seen in the video, yes.
And when you're looking at the video of you driving away from the crime scene, of you throwing your newborn baby into that dumpster, you didn't hit any walls on your way out, did you?
Not that I'm aware of.
You didn't veer at all one way to the left, one way to the right while operating your vehicle, did you?
Not that I remember.
And it's your testimony that you were able to do all of this while blacked out. Is that right?
Yes.
Blacked out being your word. Is that right?
Correct.
You weren't blacked out while you were working the night before, did you?
Well, I don't remember working, like what I was doing at work, so.
But you do remember being at work.
Correct.
And that's because you were at work.
Yes.
It's just with reference to you being informed that you're pregnant for the, Is it the second time, third time?
The first.
First time. So you're denying your August pregnancy result then.
I took the negative.
And you're denying having discussions of pregnancy with your friend by phone.
No.
That's because you did have discussions about pregnancy with your friend by phone. That's because you did have discussions with your friend by phone regarding the subject of pregnancy. Is that right?
Yes.
People were talking about you being pregnant at school. Is that right?
Yes.
And let's talk a little bit about the exact time period of this blackout. Do you remember the first hour that transpired after you threw your baby into a dumpster? What you were doing?
No.
Do you remember the second hour of what you were doing after you had thrown your baby into a dumpster while you were at your house?
No.
Do you remember the third hour of what you were doing after throwing your baby into a dumpster?
No.
Do you remember the fourth hour of what you were doing after you threw your baby into a dumpster?
No.
What about the fifth hour?
No.
And that's because at no point did you ever go back to that dumpster to find your baby who you had thrown away, did you?
I'm sorry?
That's because at no point did you go back to that dumpster to save your baby's life, did you?
Right.
Now, when you were talking on direct examination, you provided testimony about your thought process during the interview, about wanting to take your baby back. Do you remember providing that answer on direct examination?
Yes.
And about your thought process at that time, that he's still mine. That was your answer, wasn't it?
Yes.
And so you're able to remember that part of your interview, are you not?
No, I don't remember the interview.
Do you remember hearing your interview in the courtroom and being confronted with the question from Detective Perez about what, if anything, would change if you knew that your baby was dead rather than alive? And do you recall what your answer was?
No.
You said nothing. That was your answer. Did you black out providing that answer?
Well, I don't remember the interview, so I can't tell you.
You provided information during the course of your interview with Detective Perez about not just the August pregnancy test that you took, but also that you knew that you were pregnant, but also didn't know. Is that right?
I'm sorry, you're going to have to say that one more time.
You said you knew, but didn't know, in reference to your status as a pregnant woman in the months leading up to January 7th. Isn't that right?
Yes.
You heard yourself make that statement in the video, that's why. Is that right?
I'm sorry?
You said that statement in your interview that you saw. Is that right?
Which statement? Sorry.
The recorded interview between you and Detective Perez. You said that during that same interview. Is that
I'm
correct?
asking what I said.
Knew but didn't know that you were pregnant.
Okay.
For you, are the facts just something that you can just believe in and it'll be real?
I'm not understanding the question.
Is reality something that conforms to you choosing to believe it or not to believe it?
Does reality choose what I get to?
Let me reframe the question for you. What in the world does that mean? To know something, but then to not know it. What does that mean to you? In your own words.
Exactly what you just said. I knew, but I didn't know.
You had received positive pregnancy results.
Just one.
You had been discussing the subject of pregnancy just with the evidence that you've seen so far.
Sarcastically, yes.
You've also spoken about being pregnant with the father of this child, haven't you?
I don't remember.
And in fact, during the course of your interrogation, you even knew who the father was, didn't you?
Yes.
And yet you're claiming to have blacked all of that out.
Yes. Have you ever been blacked out?
Well, we're asking you the questions, ma'am. You're the one that threw the baby into the dumpster. Your Honor, one moment to confer with counsel.
Okay.
No further questions.
Redirect.
Yes, Your Honor. Okay. You knew, but you didn't know. Let's talk about that for a little bit, okay? So, there was a test that you took?
Yes.
When did you take a pregnancy test?
I believe what he said was August.
Okay. August of 2021.
Yes.
So, why did you take a pregnancy test in August of 2021?
It was a TikTok trend.
What does that mean?
A TikTok trend?
Yes, what does that mean?
It was basically going everywhere on TikTok.
What was going everywhere on TikTok?
Taking pregnancy tests with your friends.
Who was doing these things, taking pregnancy tests with friends?
Just people who are on TikTok, the ones that are famous.
So there were several people at that time just randomly taking pregnancy tests for TikTok.
Yes.
So you decided to do it too?
Oh, yes.
Was it just you?
No.
Who else?
Me and either 2 or 3 other people.
Who are these other people? Were they friends?
Acquaintances.
Okay. So you all decided to hop on this trend that was happening.
Yes.
How many tests did you take?
2.
And you mentioned that one was positive
Yes.
and one was negative.
Yes. What did you do with that information? Nothing. I didn't put much thought into it.
So you just ignored it?
Yes.
Now, when you saw Officer Perez, Detective Perez, and he interviewed you, as the state just said, you waived your rights. Did you understand what you were doing in that moment?
No.
Why did you waive your rights at that time?
I couldn't tell you. I don't remember.
And one of the things you told him was that you did put the baby in a trash bag. You put a hair tie on it that was, you think it broke, right?
From what I've seen in the video, yes.
So that testimony that you're giving us right now is based on watching the video. Now, one of the things that was emphasized over and over was that there had been previous hearings about this case. You do remember going to court about this case before, correct?
Yes.
Okay. And around that time, were you able to confront the facts of this case and what you've done?
No.
This hearing that the state talks about, was that before or after you'd seen Dr. Cade?
Before.
Okay. And when you saw Dr. Cade, she did an evaluation of you, correct?
Yes.
Okay. And she was evaluating you at that time for competency. Do you recall that?
Yes, somewhat. Yes, ma'am.
That evaluation was in May.
Your Honor, objection is irrelevant and the officer withdrawn.
Sustained.
So, but you don't recall, do you recall any details of the hearing in February of last year?
No, ma'am.
Okay. Now, the state also said a whole lot about your blackout. You attempted to explain what that meant to you. When you say you black out, what do you mean by that?
Like I'm not in my body, like I'm a ghost.
Could you describe that a little better for the jurors?
I guess like I'm in my body, but I'm not.
Are you able to clarify that anymore?
No, ma'am.
Detective Price asked you, what would change if the baby had died? Based on what happened at that time. And you said nothing. Do you know why you said that?
No, ma'am.
Do you know what you meant by that at the moment?
No.
But the baby did not die.
Correct.
There were also questions about whether or not you knew the father of the baby. You said you did. How did you know the father of the baby?
He was the only person I was ever with.
Could it have been somebody else who you had not been with, who was the father?
No.
So if you had a baby, that automatically means that it is the person who you had been with. And by that, we mean somebody that you had sexual
Yes.
intercourse with.
Yes.
Okay. And so the individual who you said was the father is the only person, correct?
Correct.
So you know that that is the father of your baby. Now, earlier, as Detective Perez was testifying, there were some text messages that we saw between you and somebody. And there was a conversation in those messages, correct?
Correct.
You did not admit to being pregnant in any of those messages, did you?
No.
There was communication about people talking about you being pregnant.
Correct.
Was it because you told all these people that you were pregnant?
No.
Were people just saying and spreading rumors, maybe?
Yes.
You were in high school at this time. Is that something that happens in school? Where people talk about things and spread rumors?
Oh, yes.
And that's exactly what was happening here?
Yes, ma'am.
Because you did not give that information to your schoolmates about this.
Correct.
May I have just a moment, Your Honor? We have no further questions.
Any follow-up?
Your Honor, very limited. Ms. Avila, we just heard on redirect the new TikTok angle of your pregnancy test in August. Do you remember providing testimony in relation to that?
Just
Just now,
Yes.
or did you black that out?
no.
And with regards to this TikTok pregnancy test, you did it with your close friends, didn't you?
I didn't have very much close friends, so
But you did do it with the ones that you had, didn't you?
I'm sorry.
But you did do it with the ones that you had.
No.
So you
Just
didn't do it with your friends?
Acquaintances.
So you took pregnancy tests with acquaintances on TikTok, is that right?
No.
Okay. Who did you do this TikTok channel
With acquaintances from here, not from TikTok.
But these were still people that you knew.
Yes.
Who else's test came back positive other than yours?
I don't remember.
Okay, no further questions, Your Honor.
Any follow-up?
No, Your Honor.
Any questions from the jury for Ms. Avila? A juror would like to know when you had your back injury.
Sometime 2020, I believe, when COVID started, somewhere around when COVID started.
And the juror would also like to know, how often do you have back pain?
Oh, every day, if not every other day.
Any other questions from any of the jurors? Okay. I'm going to rephrase this one just slightly, but the question from the juror is, when did your blackouts begin?
On the 6th, on January 6th.
Not before. A juror would like to know, were you taking pain medication on January 6th, 7th?
And not on the, on the 6th, yes, but whenever I went to the clinic in Hobbs, the doctor that seen me told me to stop taking the medication.
A juror would like to know, were you alone when you took the 2 pregnancy tests for TikTok?
No.
Any follow-up questions from the juror? Any other questions? Any follow-up from the state?
No, Your Honor.
Any follow-up from the defense?
No, Your Honor.
You may step down, thank you. Any further testimony from the defendant?
Your Honor, there will be no further testimony. We will rest at this time.
Any rebuttal by the state?
Yes, Your Honor. The state calls Stephen Sorga.
And for the record, all prior motions are renewed with the same result. For purposes of the record.
Laura, maybe the interpreter check the battery on that
You may have, should.
transmitter, please. Your Honor, we're going to replace this.
Right. I'll wait till you do. Sir, I'll swear you in just a minute. They're working on the equipment. As soon as they get the battery replaced, I'll swear you in.
No, we're getting a portable transmitter. We don't have another one to replace it.
You okay to go?
Yes.
Okay. You'll raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of law? Yes, sir. You may be seated. Make sure you speak up into the microphone.
Yes, sir.
Thank you.
Good afternoon, sir.
Hello,
Could you please introduce yourself to the jury by your first and last name?
my name is Steven Astorga.
Mr. Astorga, do you know a person by the name of Alexis Avila?
Yes, sir.
Is she present in the courtroom here today?
Yes, sir.
Could you point her out by an article of clothing?
Light
And point
pink.
with your finger as well.
Right there with light pink.
With light pink?
Yes, sir.
Okay, and I see that there's several, I actually do see some pink, so when you're saying light pink, what article of clothing are you referring to, sir?
She has a brown shirt, undershirt, right there,
And is she sitting or standing up?
sitting with glasses to your left.
Okay, Your Honor, may the record reflect the witness identifying Ms. Avila?
So reflect.
How long have you known Ms. Avila, Mr. Astorga?
About 2 years.
10 years?
2.
2 years?
Yes, sir.
Did you ever have any sort of relationship with Ms. Avila?
Yes, sir.
As a result of that relationship, did you have a child with Ms. Avila?
Yes, sir.
You weren't present for the birth of that child, were you?
No, sir.
When did you first get the news that Ms. Avila was expecting?
Around April of 2021
April of 2021. And how did you receive that information?
by pregnancy test.
And did you observe the pregnancy test, or did someone tell you about the pregnancy test?
No, I observed it.
Observed it.
Yes, sir.
And the pregnancy test was, I presume, administered with Ms. Avila?
Yes.
And she was obviously present for this pregnancy test, is that right?
Yes, sir.
She appeared to see the pregnancy test or to not see the pregnancy test?
She seen it.
Did you ever discuss this pregnancy test?
Not that I recall.
Did you ever discuss what you were going to do with the baby at that point in time?
No, sir.
Did you continue in your relationship with Ms. Avila?
Yes, sir.
Approximately how long was your relationship with Ms. Avila?
Altogether, after I found out,
Yeah, after you found out in April.
about 2 more months.
2 more months?
Yes, sir.
And with reference to the pregnancy test result back in April, what were you doing in terms of school or work or otherwise?
I was still attending school, and then
What about Ms. Avila?
she was sometimes there, sometimes she wasn't. Just depended.
Did you guys go to the same school?
Yes, sir.
Which school was that?
Outside,
What grade were you in?
I was a junior,
What grade was Ms. Avila
senior.
in? And she was attending school at the same time that you were, I presume?
Yes, sir.
Did you also have any sort of jobs in 2021?
Yes, sir, too.
And what about Ms. Avila? Were you aware of her having any jobs?
Just one.
Where was that?
Martin Boot.
And with her work and with school, were you aware of any sort of difficulties, either at work or school, during the time that you were in a relationship with her?
No, sir.
Were you aware of any sort of blackouts or any sort of serious medical conditions like that?
No, sir.
And is this at any point between April and the months afterwards while you were in a relationship with Ms. Avila?
Can you repeat that?
And with reference to sort of your basis of knowledge, this is based off your experiences with Ms. Avila in this time period, is that right?
Yes, sir.
How well do you feel that you got to know Ms. Avila during the time that you were in a relationship with her?
Pretty well.
What was your reaction to the news that there was a positive pregnancy result?
Excited?
Were you able to observe her reaction?
No, sir.
Were you able to discuss it with her?
No, sir.
Were you able to discuss any sort of plans with regards to a pregnancy?
I was able to, but never discussed it.
Why not?
Didn't feel it was the right time because I was at my friend's house at the time that I received the pregnancy test.
So there was no point where you had a discussion regarding this pregnancy?
No, sir.
What about other people? Were you able to tell other people about the positive result?
Just one of my friends.
Okay. Did this friend go to the same high school?
Yes, sir.
With regards to the baby, when was the first time that you were able to see your baby after he was born?
About a week after when I picked him up from the hospital in Lubbock.
And just to be clear, you were not present at the baby's birth, is that right?
Yes, sir.
But you have been present since you were able to get custody out of the hospital of the baby, is that
Yes, sir.
correct? How's the baby doing today?
He's doing well.
Any medical conditions at this point in time?
No, just possible heart murmur, and that's pretty much all.
What about his lungs?
They're good. He had some difficulties with asthma, but as of right now, we're still going to a specialist for all that.
Okay, but other than having to see that specialist for the lung issue and then potential heart murmur, baby's doing okay today?
Yes, sir.
All right, good news. Your Honor, the state passes the witness.
Cross-exam?
Yes, Your Honor. Good afternoon, Mr. Stroger.
Good afternoon.
So let's talk about when you indicate that you first heard that, you first knew that April was pregnant, Alexis was pregnant. You said that was in April?
Yes, ma'am.
April of 2021.
Yes, ma'am.
Okay. We've been in court before about this case, correct?
Yes, ma'am.
And you have testified in court before about this case at least one time prior to this.
Yes, ma'am.
Okay. And at that time, you told us that you didn't know. Do you remember that?
Yes, ma'am.
But today, you're telling us that you got a pregnancy test in April.
Yes, ma'am.
Okay. When in April did you get this pregnancy test result?
I don't know an exact date.
Do you think it was early April or maybe later in the month?
Later on in the month, maybe 2 weeks or week left in April.
A week left in April?
Yes, ma'am.
And so at that time, you said you did not discuss this with Alexis at all.
Yes, ma'am.
So you just found out, you're telling us today that you got a pregnancy test from, did you see her do the test?
No, ma'am.
You didn't?
No, ma'am.
Okay, and you're saying that you didn't talk about it?
No, ma'am. She had taken it to me to where I was at.
Okay, but the previous time when we had court, which was last year, correct?
Yes, ma'am.
In fact, it would probably be around February of 2022, correct?
Yes, ma'am.
And this had just happened in January, and in February, a month later, you did not know that she had been pregnant.
Yes, ma'am.
Okay. Okay. Now let's talk about the baby now. I'm very happy to hear that he's doing well.
Thank you.
And you said he has a possible heart murmur?
Yes, ma'am.
Yeah, I heard recently that apparently I have one too, but. And you said he has asthma?
Yes, ma'am.
Okay. What about yourself? You have asthma too?
Yes, ma'am.
Okay, all right. Thank you. I don't have any other questions.
Any redirect?
No, Your Honor.
Any questions from the jury for Mr. Astorga? All right, you may step in and you're excused. Thank you. Any further rebuttal testimony from the state?
No, Your Honor.
Okay, ladies and gentlemen, the case is at a close. It's 3:15 in the afternoon. The attorneys and I will be working on jury instructions for you in the morning. I'm going to bring you back later in the morning because I want to make sure those jury instructions are absolutely done by the time you get here, and I don't want you waiting around in the jury room. I'm going to bring you back in at 10 o'clock in the morning. And what you can expect is at that time, hopefully we get started promptly. I'll read you the final instructions of law. Each of you will receive a copy of them when you deliberate in the jury room. The attorneys will be given an opportunity to make closing statements. So once again tonight, I've said this a few times, you could probably repeat it yourself, but don't discuss the case with anyone. Don't allow anyone to discuss the case in your presence. Don't do any independent research about the case. Don't read the newspaper. Don't get on social media. Don't watch the local news. And don't form any fixed opinions about the case until you've been instructed on the law and you've heard the final arguments of the attorneys. So if you'll be here, say like 5 minutes before 10, we'll try to promptly start at 10 o'clock. Please stand for the jury. You may be seated. Okay, well, what I normally do, I'll do in this case, and that is we're going to go off the record for a minute, or more than a minute actually, and talk about the instructions. Obviously, I'll give both sides a chance to make a record on any of the instructions that they object to, or any instructions that I failed to give. I've spent some time looking at what's been proposed by the state and the defense. And let's go ahead and go off the record. And we'll go back on the record when we need to. Oh, I left the new ones on my desk. I'll go get them and I'll be back out just here shortly.
Oh, okay. So,
And then, knowing that we needed a quick summary, I'm sure you know that, it's about what the statement that the defendant was calling. So that one wasn't in the set.
We're off the record.
So, that way, there's your copy.
cool, thank you, Mr.
And Your Honor, you are corrected that, you said have the, just say baby boy now. And then the ones that's missing, 14504 Road, the instruction is required to be put in that whether or not that confession of the defendant was voluntary. If the jury has to consider that, considering the weight of that. That one was missing.
Okay, let me give you my, not necessarily my final thoughts, but just my first thoughts when I looked at these. Based on the evidence that I heard, I do think there's a basis for giving a step down on the attempt to commit a felony to a first-degree murder. I don't think it steps down to voluntary manslaughter, but I do think the jury, based on the testimony from both Ms. Avila and Dr. Cave, could decide there was no deliberate intention, that it fit more within attempted second-degree murder. Voluntary manslaughter would require, on the provocation side, that a reasonable person would have reacted in the same fashion, and I don't see any world in the world I'd give that, because I don't think any reasonable person would have done what was done. You know, I'm not ruling, I'm just telling you my preliminary thoughts. The child abuse resulting in great bodily harm, I see the defense is trying to get an instruction on simple abandonment. And I'll hear argument on that, but I'm not warmed up to that idea yet. You'll have to convince me. In general, the instructions need to be following the UJI. It appeared to me that a couple of these weren't consistent with the UJI. What I'd like you to do is, are there any instructions that the state and the defense agree upon in this case? Maybe we could get those in the stack, and then I could sort out the ones that there's going to be argument on.
I don't know, Your Honor. I haven't heard from defense about any of our instructions. We did follow them. I know that our count one child abuse, great bodily harm, was missing a line when I typed it, so that's been corrected and provided to them. So I don't know.
The child abuse resulting in great bodily harm instruction seems to track the UJI to me, but I'll hear argument on it. It certainly needed what great bodily harm, the definition.
Right, we added that to our second, the one that you have.
So, Judge, my thoughts, if you will, like, somebody interrupt,
No, that's fine.
On their child abuse resulting in great bodily harm, there's missing great bodily harm, they got that. Let's see, 5, 6, 7. I tracked mine with Westlaw. I'm assuming that's the same as the UJI, standard UJIs. I don't think you have to have element 4 in theirs. It's only if it's in issue according to the use notes. I don't know that it matters a whole heck of a lot, but I know that's why I didn't include it in my third-degree child abuse step down, because it says in the use notes, if that is an issue, then it's not an issue. I don't think anybody's going to be getting up arguing that she's not the parent of the child. So,
I agree that's not an issue.
And I don't have a problem with their instruction other than that. Their instruction 6001 is fine with me. 5060, which is,
Hang on, you're going too fast.
oh, sorry, Judge. Sorry, Judge. Yeah.
Okay, I'm going by the UJI number.
Yes, sir.
What number did you give?
So I'm looking at the plaintiff's requested instructions. 146001, I believe, is.
It's the law governing the case.
Oh, well, yeah, nobody, that's always good.
Yeah, well, I didn't know if you wanted me to bother. You want me to go to the more substantive ones, Judge? Is that what you're talking about?
Yeah, the ones that are stock, I mean, we're not arguing about the ones that are given in every criminal case.
Okay, okay. Wasn't sure.
Let's look at let's start with like 2801, attempted first degree murder. And I've indicated that I think it probably, the evidence, I think the jury could consider attempted both first degree murder or step down to second degree murder.
Yes, sir.
And I can tell you, I'm not going to give them on manslaughter. There's provocation.
Well, I went there, Judge, because of the language and provocation. It's like, it's a list of all these emotions, and it's not exhaustive, and I thought.
But the last line, as I recall, is that a reasonable person would have acted.
That's true, but that's a jury question. That's a jury question.
Well, I'm not going to give it.
Okay.
I think that there is limited psychological testimony in this case. And I almost didn't give the instruction that I ordered would be given because Dr. Cave didn't quite get to where I thought she was going on sudden impulse. She never got there. So there's no testimony that, in my view, that a reasonable trier of fact could find that a reasonable person under similar circumstances would throw the baby in a dumpster.
Fair enough.
But I do think there's sufficient evidence in the record that they could find it wasn't premeditated.
Understood, Judge. Like I said, for the record, I'm proffering it, but you're denying it. That's
No,
fine.
we're not on record yet. I'll allow you to make a record.
Yes, sir.
Both sides. The state can object to the step down. If you want. Does the state have a position on the step down?
Which
On first degree murder and second degree murder. Attempted first and second.
the state doesn't believe it's that, but we're going to object to the step down because you and I both know that's the most picky issue of the appellate.
Right. And I don't think anybody particularly wants to try this case twice.
Although that's why you should be voluntary.
No, that's why I'm not getting involved.
I'm kidding.
Okay. So let's kind of work towards doing a step down on attempted first degree murder and second degree murder. Let's look at the child abuse resulting in great bodily harm. I agree that number 4 doesn't need to be in there, that she's the parent, guardian, or custodian, although it's not disputed, but it doesn't need to be in there.
Okay, so you want the state to take out number 4 on 14.615.
Yes. Does the defense have any other objection to that one?
No, sir.
Okay, so we can give that one, we'll take out. Okay, then there's the great bodily harm definition. You had a different one I thought I saw from the defense.
Well, I had to submit one with the second degree. That was part of it. I know they already submitted one. I don't think you need 2, but it's however everybody wants.
Well, I'm inclined to give the one that's right out of UJI.
Yeah, mine's out of the UJI as well. The one they used is there's bracketed material. You're really supposed to select the bracketed material. I don't really.
Well, that's the first time I've heard a defense attorney say they're only supposed to select the bracketed material. That's why the state put it all in there, because they always object and they make us put all the ones in here. Every trial I've done in the field. So I want that statement on the record. Get the recording when we trial that the frame of my office.
Well, let's look at it. Let's see if some of it is. Great bodily harm means an injury to the person which creates a high probability of death. You can, that part, or serious disfigurement. I don't think that's really based on any evidence in this case. Or results in loss of any member or organ. I think that could stay in based on some of the doctor's testimony.
I'm asking for it just to be the way I wrote it.
Let me look at yours. I'm flipping back and forth, and
Yes, sir. Why is this
yours are not in the same order as theirs, so hang on.
All right, my microphone. Sweet. Well, I don't know, it doesn't work. I know, but it's frustrating. It's frustrating. I'm hangry, it's frustrating.
Judge, are we still on Zoom?
Yeah.
Are we gonna stay on there for this discussion?
They asked me that. I don't want anyone to say we cut them out of a open court, but we can go off to the wind if you want for this.
Could we please? I think my secretary's on there who's helped with the jury instructions, so it's up to you. And I think a lot of the public defender's office have been on there too.
There's a myriad of people on there.
It's okay, we'll be fine.
Yeah. We'll try not to say anything too stupid, okay?
Noted.
Yours reads just great bodily harm means an injury to a person which creates a high probability of death.
Yeah, that's based on the instruction, I think you gotta pick. I don't know if you can have all three, but
I would take
I
out,
think my co-counsel even disagrees with me, so, you know.
I would take out or results in serious disfigurement, because there's nothing about disfigurement. But I would leave in or results in loss of any member or organ, because there was medical testimony that but for medical intervention, that the baby was in danger of organ damage. And of course, the defense can argue, but that didn't happen. So I'm going to take out or results in serious disfigurement.
Yes.
Okay?
You want me to fix it, or do they want to do that, or how's that gonna work?
The state will fix it.
Okay.
Yes, ma'am, thank you.
All right.
Hey, what instruction is that again, Judge, the number?
That is 14-131,
All right.
unless you find something else in the use note.
Yes, sir.
Attempt to create first-degree murder is a specific intent crime. And then there's, the instruction is written includes the general intent. And
Well,
for-
I think my staff just always do that, they just list all the crimes in there, and that's why that child abuse for probably crimes.
But the one I've got in front of me doesn't have it in there.
I took it out, I corrected that. But yeah, there's probably no general intent on either one of the state's proposed elements instructions. But there would be an intent to commit second, right?
Yes. It would be on second, but not first.
Well, the only reason I thought it wasn't on second was because it's a specific intent crime once it becomes an attempt. That's the only reason I didn't put it in mine. I just put what I think I put, child abuse and the top charge resulting in great bodily harm.
But that has its own intent within the instructions.
Does it?
To the use of.
Yeah.
Okay, that's cool. It is what it is.
would take out the attempt to commit first-degree murder. And I would put in the attempt to commit second-degree murder and the child abuse resulting in great bodily harm. And if there's, I'll welcome any discussion on that. I know that there's a case.
Well, Your Honor, I have the child abuse, great bodily harm in there, and yesterday you told me, that we agree with you that it should not be in there because it has its own intent within the statute, because really, the child abuse.
I was actually talking about first-degree murder, but, and I know we've given it in other murder trials, I know that we have.
It's harmless error to put it in the general intent. It's harmless error if it's in there. You can't tell them too many times to think about intent.
There's a, let's see if I can find it.
I don't see the intent built into child abuse resulting in great bodily harm.
There's an old case, State versus Sheets, 1980, Mexico Court of Appeals 41, that talks about the general intent instruction, which has been modified since that date a little bit, but they say it's a mandatory instruction adopted by the Supreme Court to use in all cases except no intent crimes and first and second degree murder and involuntary manslaughter.
Then we put it in there all the time. That's still the current law.
And I did a little research trying to see if there was anything jeopardized after that. And I didn't find anything. That's not to say there's not something out there, but I didn't find it. But that would say even second degree murder is a specific intent crime. I don't have a problem with putting it in there for all of them and hope that the Court of Appeals finds it harmless error. But
I think you gotta have it on child abuse resulting in great bodily harm. I don't see in that instruction, I see reckless, I just don't see an intentional aspect to it.
Well, I think you're probably right on that. Do you want to do it on every crime?
No, Your Honor, state's not worried about the intent level.
Yeah.
In the general intent instruction. So I'll put child abuse, great bodily harm back in there. I had it in there originally.
Okay.
And then we'll see what other, if other elements are different, we'll talk about that they go in there too.
Well, you'll have to have an attempted second degree murder too.
I thought you just read that you don't put first or second or both.
Yeah, I did just read it. That's why I was asking you guys, do you want to put it in?
Just for,
Well, defense had just said that it's a specific intent you need to go in.
I didn't.
You said what?
I didn't think it went. The one I did, I just put resulting in great bodily harm, and I think I did. I can't remember. I have to look at it. I can't remember where I put it.
But you would have to put any child abuse element instruction that's given, they would have to go in. If the first one has to go in, the all of them,
There you go.
on the child abuse.
Yes, sir. I'm trying to find it here. What's the number again on that, Judge? The general intent?
It's 14-141.
14-141.
I don't think the general intent instruction should be given in specific intent crimes, is what I really think. Because you have to give the specific intent in the elements.
In mine, I just put child abuse resulting in great bodily harm and child abuse, that they gotta consider that general intent. I thought that was correct. How do you feel about that?
Well, you have two different child abuse statutes, we have health and we have child.
Oh.
Well, let's talk about that maybe, so we'll get that out of the way.
The third degree one, I got the step down.
Yeah.
Yeah, I don't know how you can't not give it.
Well, hang on, what's your number on?
Let's see, where is it? I don't have the credits. You have the beginning, should be my first instruction. Yeah. 14612. It tracks the same language they use, except it removes great bodily harm, and that's
Let me read it.
Yep.
It is your first one.
And I think I gotta change baby boy of VA to baby boy if we read it. So let's see, I'm gonna write that down. Yeah, thought I was done with all this, Judge, took me forever. I'm not complaining, I'm just saying. Just saying.
Okay, this is the step down. What's the state's position on giving an instruction on simple child abuse? What's your position on they're requesting an instruction?
They're arguing there's no great bodily harm.
They're
Right.
arguing no great bodily harm.
Right. The state has no objection to their instruction as long as it's like ours, just cleaned up to make sure it conforms to this baby boy. We recognize their theory and we don't have an objection to
That's
it.
kind of
But we
what-
want them to correct their, do their own step down, 6002A, 6002B, and 6012.
12.
Yeah. Okay, I'm inclined to agree with you. I think that's their theory of the case. Right?
Yes, sir. One of them.
I understand. One of your theories of the case.
But we're getting some input that there are others that think that we should put attempt to commit second degree in the general intent. That there's no harm if it's a higher intent in its own instruction, but that they think it should be in there.
Well, you know, had I not read that case, I'd say the same thing. That was my initial take. But when I was looking, I don't have a problem putting it in there. But
I don't either.
okay, let's put it in second degree.
Are you?
And that's an old case, and there's probably something more recent, but I couldn't find it quickly.
Right. So you're gonna take, are you doing that?
Yeah.
Okay, thank you. I'll change baby boy in 14612. That's all I gotta change, I believe. I believe it otherwise tracks their instruction, just removes the great bodily harm, and I just gotta change the name. We all agreed on that? Still on. Just wanna make sure I get it right.
Right, I mean, I haven't proofread yours for, just like it's hard to proofread my own, so I am relying on Alyssa to proofread, so.
What do you think?
So I don't know if she didn't have a copy.
No, but I have it.
She hasn't,
Diana, do you have a copy of our documents?
do I have what?
A copy of our documents?
Okay, defense has got 14606, and to find that the defendant intentionally left or abandoned the child, you must find that it was defendant's conscious objective to abandon the child.
Well, that's because I also put in 14606, judges.
That's one I just read.
Oh, I'm sorry. I thought you were talking about something else. I'm sorry. Yes, sir.
Your Honor?
Yes.
May I address the board?
Sure.
Just for purposes of any of the attempts, just for some case law with regards to both attempted first-degree murder and attempted second-degree murder, the case I'm looking at is from the Court of Appeals, State v. Johnson. The vendor-neutral citation is 1985 NMCA 074.
Run that by me again, 1985 what?
1985 NMCA 074.
What's it say?
And I'm tracking in paragraph 10, discussion by the Court of Appeals, that any crime of attempt is a specific intent crime. since it necessarily requires an intent to commit a felony and intending but failing to effect its commission. It may be not proper under the rubric of our Court of Appeals instructing us that, first and second degree murder, that's one thing, but anytime you're attempting to commit a felony in Mexico, it is a specific intent crime. And
Okay, well then let's leave the attempts out on the general intent instruction, and that would be consistent with that case that I cited to you.
Right.
Cool.
Yeah.
I'll go with that.
All right, we'll go with that. What other step downs are you asking for?
I got the 606,
Which is the one I just read.
Yeah.
Okay.
and the reason I run that, my thought process is it's not far off from what the top charge is paid on.
Okay, so, here's case law.
All right.
Case I tried, State versus Miranda Kirkendall.
Yeah.
The court actually said, no, abandonment is a different crime. It's not a lesser included.
What's the side on that? Do you have it in front of you?
I just had like an excerpt, and it was actually the unpublished opinion, not the published one, because they first dealt with the wrong verbiage on the top of the verdict form, remember?
Right.
So I don't have the reported.
Do you have the quote from the unpublished opinion?
Here, I can just.
Show it to Raymond and then show it to me.
Is that just a 3D child use case?
It was first through child abuse resulting in death.
And then it was abandonment resulting in death, was that somebody requested that?
I'm sure just like.
And they didn't get it, and then the court affirmed. Well, this ain't a death case, Judge.
Let me read this first.
Yeah, I get it. Well,
It's an alternative crime.
that's probably the best argument you got. It's not less. So, if we don't get it, I'm sorry.
Okay, well, that seems to answer it right on the money, that it's not a lesser included offense, so I'm not gonna get it.
Understood.
Yeah.
So, what else did I ask? I think that's all I asked for, Judge. And then, and you're not gonna get the voluntary, so I ripped that out, that's cool.
No voluntary.
And I get rid of the abandonment. I changed the name to Baby Boy, they changed the general intent.
Right.
I think we're good to go. Now,
You've got that step down,
do you know why I did that? Did that make, I did it because it's in the alternative. So I did two. I used, you know what I'm saying?
Right, you have to do one from attempt to first, the second, and you have to do one from child abuse.
it's gonna be a long read.
And you gotta do the multiple verdicts, yeah.
Well, I did it though. You saw that.
I agree.
Yeah. I was just worried everybody's gonna say, oh, you should have put it into one. And I tried
You
that
have
before.
to do it separate.
No,
It's a nightmare. So I
Did
did
you
that.
ever?
So I was good on it.
you did it the right way.
Yeah, which
In my view.
took a long time.
No, it did.
Whoever came up with that, they
Okay, now is there any others? Here's what I propose we do. You know, I'm bringing the jury back at 10. Do you think if we get here at 9, we can have our instructions in a clean pile by 10 o'clock? I'm asking.
Say that one more time.
Do you think if we all come in at 9,
Yes, sir.
do you think that we can have the instructions ready to go at that point?
I think so.
Time to make a record, or if you want to make a record on any instruction.
I think we can do that.
What do you think?
That's
Diana? 9 o'clock work for everybody?
Your Honor, if I may be heard on the child abuse instruction, I'm tracking some changes that need to be made.
Sure.
So the first being a defense, and I can go over this with Mr.
Why don't you come up? I can't hear
Hear
you.
me, okay.
You're talking
Yeah, I
about
can.
the child abuse instruction 14, 16,
Yes,
112?
and
I
we
hear you
were
now.
determining whether defenses was tracking the states in the alternative. First and foremost, I think at the top it needs to include that, the language that this is an included offense of count 1, or as charged in
I
count 1.
agree with that.
That's missing. We also refer to Miss Avila as Alexis Nicole Avila, which is missing from defense's copy.
You want me to insert Nicole in all these?
I mean, there needs to be consistency, so that would be my position.
All right.
Did the
Hey,
states
that's
use
cool.
the middle name too?
The states do.
Okay.
Okay.
And then, element 2, by engaging in the conduct described in paragraph 1, Alexis Nicole Avila caused, it should say, or permitted baby boy Avila.
Well, hold on a minute. I'm gonna look at something real quick before I read it.
Well, hang on a minute. I thought we looked at 14615 that was prepared by the state. And the only thing we were gonna do, and Raymond agreed, was take out paragraph 4 and renumber.
Right, which is
So
why
why are we
it's,
going through this?
This is their lesser included
Oh,
charges.
okay, all right.
and it doesn't track
Doesn't
ours.
track ours.
All right, I didn't look at it carefully.
Well, now that this is, maybe I wasn't paying close enough attention. I think when you look at the use notes, they don't get all that language. They gotta select out of bracketed language what they want. Now, maybe I'm wrong. Looking at the child abuse, I'm just gonna look at the non-result.
Well, it does have to be plain to the jury that it's a lesser included offense.
That's fine. That I understand. I can say as charged as a lesser included offense in count 1.
Yes.
So let me just write that down.
All right. Alyssa, what else were you want to tell me? Looks like you've looked at it pretty hard.
And then, so we're missing the or permitted on element 2, and then we're missing the without justification on element 3.
Okay, that's where I'm gonna maybe take issue with theirs versus mine. In the use notes, the cause permitted, I think you gotta pick one or the other.
You know, it says in most cases, only one of the bracketed alternatives should be given. However, both alternatives may be given in the same instruction if the evidence supports a finding beyond a reasonable doubt that the defendant either caused or permitted. She threw and left the child there. So it's caused or permitted.
Let me just look at it. Cause or not that. Yeah, let's, is that element 3 guys?
Use note 3.
Oh, yeah, use note 3, element 2. All right, caused or permitted. Why is it both?
I know you haven't been in the case very long, but you haven't been here for a trial.
Yeah, well.
Caused, threw
Don't
the
tell me.
baby into the dumpster, permitted, she left the baby there, the baby was there in the cold, no food, in a plastic bag for 6 hours.
Yeah, I would imagine one or the other of those. We're struggling over.
Our theory, our verdict.
Right. You agree with them, Judge, or what?
I'm reading the use note.
I don't know.
They cite State versus Wayao, 1986 New Mexico Court of Appeals 75. Says since abuse will frequently occur in the privacy of the home, well, that's not what this has. Charging a defendant with causing or permitting may enable the state to prosecute where it is not clear who actually inflicted the abuse. But the evidence shows beyond a reasonable doubt that the defendant either caused the abuse or permitted it to occur.
That's why it's caused. Right? That's why it should just be one of the caused. That's what I have. I have caused. She caused it. She didn't permit it. She's the one that caused it. I don't know how.
Well, the line that the state's reading is both alternatives may be given in the same instruction if the evidence supports the finding. Beyond a reasonable doubt, the defendant either caused or permitted.
Well, yeah, but I don't think it's unclear in this case, right? I have been here during this trial, and I don't think it's an issue of whether or not she permitted it, that she caused it. I don't know.
I think it's almost a distinction without a difference.
I think you're probably right.
I want you guys are going to be arguing to the jury, to tell you the truth, but on either side.
Yeah, I agree.
I don't have a problem with putting in both
All
cars.
right, I'll change it. I'll just change it. That's fine.
Okay.
That's it.
Yeah. Thank you.
Just tracking those changes, so
All
they're
right.
consistent.
Okay.
Is it, real quick, Judge, is it consistent otherwise? Mine is with yours?
The one, just the notes I gave you, the included offense, the baby boy, the name, and then the elements, caused or permitted,
That's it?
and,
I just don't want to fix this.
disregard without justification, you don't have that in there.
Okay, hold on. Where's that?
Okay, so we here.
Yep, yep, I know that. Cause or permitted. Or else. Without justification, I left that out. No, I don't know. I'm just tripping because I know it's that. This is mine, so it should be there. It's just without justification. Okay, so without justification, Judge, in the use notes is there if that's an issue.
Right.
So I don't know if that's even an issue. You understand what I'm saying?
I do understand what you're saying. What do you think, justification and without justification? That's normally a fact pattern where,
Well, if the court saying take it out of ours, they didn't tell us to take it out of ours, they didn't object to it, it's only when we recognize that
Yeah.
theirs doesn't have.
I'm renewing
And
mine.
now wants to argue that we
I
shouldn't have it.
understand.
That's what it is.
Well, and that's
But
why
that is
this
in the use note, that it goes in if that's an issue. Is it an issue? I don't, justification's not an issue.
It'd be like a self-defense claim.
Yeah.
Are they gonna argue she's in shock,
Argue what?
that she's in shock, that she didn't know what she was doing?
I suspect they might, based on what she said. Is that the justification you're saying?
I don't know.
That's not really a legal, I mean, it might be, go to intent issues, right? But I don't know that that's justification.
What?
It's not affirmative defense.
I agree with that.
I don't know. That's why I left it out, because I read the use note and I thought.
But it's clear from Ms. Avila's testimony that she was in shock as
Yeah.
how she justified it. And now she doesn't remember.
That's really her saying it's justified as much as she's just saying, I don't remember and I was in shock.
Do you think,
So what does the use note say?
state
I don't have my.
team, do you think justification's an issue?
Your Honor, I was trying to look at the use note because I didn't bring my UJ out of it. I'm sorry.
Okay.
So I'm looking at it on her computer. So that's what I'm trying to look at.
It says in use note 5 says if justification is an issue, if requested, this practice alternative must be given. If justification is an issue. It's mandatory if it is an issue. When she says she was in shock, is that arguing justification? Do you want it in or not, is my question.
I don't know, the state put it in. So, and I didn't realize it wasn't in there, I say.
All right, let's put it in. I'm gonna rule, put it in without justification.
All right, without justification.
Yeah. I suspect we will hear some argument about shock.
Yes, sir, I understand.
Yeah. Okay, what else we got? So we're going to give the step down on attempted first degree murder to second degree only. We're going to give the step down with simple abuse with no great bodily harm. And you're going to do all the step down stuff.
Yep.
So
Yes,
we'll
sir.
be ready to rock and roll.
Yes, I'm gonna do it tonight.
Okay. And then we're, what else have we got to clean up?
Oh, yeah. Can you send us your, the step downs, all that part tonight so that we can review it?
Oh, yeah, yeah, when I do it, I'm gonna obviously send you, yeah. Just, bear with me, you know what I'm saying? If it comes
I
to
did
10,
think,
if it's 10 o'clock, sorry, go ahead.
I was going to say, the new step down to me is more confusing than the old one.
I agree. They tried to fix it because of something that happened and they got more crazy. It's nuts.
I keep saying that whoever serves on the UJ, and maybe they're listening, whoever serves on the UJI committee, I want to know that you've done a trial with the new step downs.
It's confusing, it's more confusing, it's certainly more.
Cumbersome, very
verbiage.
cumbersome.
Yeah, very cumbersome. Okay, well, what I propose then, let's all be here right at 9.
Yes, sir.
And we'll take a look, then I'll allow both sides to make a record, and if any of us see over the night anything in the use notes where we make a mistake or know of a case, we'll fix it first thing in the morning.
Yes, sir.
So, we'll see you all at 9 in the morning unless there's something else we can do tonight.
I'm just kidding.
Okay, anybody else think there's something else we need to talk about in terms of construction?
I don't think so, Judge.
Get a good night's sleep.
Yes, sir.
Big day tomorrow.
I'll send them, same deal, send them to Candy, Ms. Rodriguez, sorry.
Yeah.
And then, if you guys get it late, I promise it's not like on purpose. It's just tease.
We're going to cut off.